I think we've just been waiting for people to join us. But can I perhaps start this conference? For those who don't know me, I'm Robert Carnwath, and before, well, some 30 years ago, I was a member of the predecessor of the Landmark Chambers, then called 4 Breams Buildings, and I then became a judge. And following my retirement from the Supreme Court last year, Landmark Chambers, now much expanded, were kind enough to welcome me back as an associate member. So I'm very pleased to be taking part in this very timely seminar. I have a few housekeeping points I have to tell you about first. I'm told that your microphones are automatically muted, so you will not need to adjust your local settings. I'm told that the question and answer sessions come at the end of each session, so please submit questions. We're very keen to get questions from the audience. I understand there's quite a large audience out there. Please submit them via text in the question and answer section, which is found at the bottom of your screen. And you can remain anonymous when asking a question, but if so, please be sure to tick the send anonymously box before submitting your questions. We'll try and answer as many questions as possible during the presentations, but if there's not time to do that, then the team will follow up after the event. I should say also that the webinar will be recorded, and you will receive a link to the presentation and the recording shortly after the event. If your connection is lost at any point during the webinar, you're invited to rejoin the meeting by clicking on the original link once more. Now, it's particularly timely, this event, because as some of you will have seen, at the end of last week, the UN Environment Council, for the first time, the UN Human Rights Council, I should say, for the first time accepted that the right to a clean, healthy and sustainable environment was a human right. And that was a sort of, it may seem slightly obvious, but it's a very important step forward at the international level. Today also sees the opening of the COP15 biodiversity gathering in Kunming, China, which is again an extraordinarily important event for the world protection of the environment. And then lastly, of course, we're coming up very shortly to the COP26 climate change conference in Glasgow. So it couldn't be a more apposite time to have a discussion of these very important issues. Domestically, we have the new Environment Bill, which sets up, among other things, the Office of Environmental Protection, and that's still going through Parliament, but we do have an interim board and an interim chairman, and we're very lucky to have here Professor Richard Macrory, who is a member of the board, and he's going to chair the first session. And we'll have an opportunity to look at some of the issues which affect that. But it's clear that the Office of Environmental Protection is intended to start quickly. It's already submitted comments on the government's draft environmental principles, which will be required under the bill. And the OEP has put in some very useful comments on those, which you can find on their website, which is already up and going. So there's a lot going on, and we are, in the course of this conference, going to discuss most of the really key issues: the Environment Bill, the Aarhus Convention on Access to Justice, climate change and air quality, and biodiversity net gain and conservation issues arising under the Environment Bill. So I think the focus will be very much on the sort of domestic application of those issues as they apply to environmental lawyers such as are gathered here today. So I'm sorry I'm not actually in person at the event. It's a hybrid event with a number of people in Landmark Chambers, but much larger people, I think, online. I'm actually at home, as you probably see from the pictures behind me. It has nothing to do with COVID, it's just that I'm recovering from a hip operation I had a couple of weeks ago, so I'm not as mobile as I hope I will be in a week or two's time. So without more ado, I'll hand over to Professor Richard Macrory, who will introduce the first session on part 1 of the Environment Bill, and he will be introducing in turn the very distinguished speakers and good friends of mine, Professor Liz Fisher and Professor Eloise Scotford. So over to you, Richard, if you're there.
And thank you again for your continuing interest in this subject, despite your operation. I'm sure you'll get better very quickly. Well, I just want to welcome everybody in this room. I've got the list of attendees, and theoretically there are over 500 people attending this by remote, and actually an extraordinary range when you look at the list of both lawyers, non-lawyers, all government people, non-government people. It really is, it's very gratifying. And I think I'm looking at the room now, and I think there are probably 1 or 2 of those who are embarking on their career in environmental law who will have actually been born after the last piece of major legislation, the title Environment Act, and that was the 1995 Environment Act. And part 1 of that act was also concerned with institutional reform. It created the Environment Agency, the Scottish Environment Protection Agency. And then later provisions in that act introduced the contaminated land regime, a national air quality strategy, and in the field of waste, it was the first mention of, in law, in national law, of producer responsibility. But that, of course, was all in the context of the maturing system of EU environmental law concerning the environment. The Environment Bill, which we're going to be discussing in this first session, of course, was constructed in a post-Brexit environmental law world. And part 1, in many ways, can be seen as the, if you like, the high-level political response to this. Now, there's a lot of ground to cover, so I'm not going to spend a lot of time introducing the speakers. I think you have their CVs in the act, so I'm really not going to do that. But all I can say is that all 3 of them are at the top of their game. So what I'm going to do is to ask each of them to make a presentation in the order of the programme, and then we'll take questions and observations, either pick up individually or all of them may answer as it were. We'll see how they go on that. Now, as Robert said, for my sins, I've been appointed as a non-executive board member of the Office for Environmental Protection, and which since July has been operating in an interim capacity. Now, I really don't have any special insights on when this bill will receive royal assent, or when actually we're going to become fully operational. I can sort of work it out roughly. But I'm going to be here in my personal capacity. I don't plan to be indiscreet, but I am going to be listening and taking notes very carefully. So thank you very much. I'm going to first introduce Liz Fisher from Oxford University.
Thank you very much, and good morning. So the second 2 of the presentations today are going to talk about the Office for Environmental Protection, and that is the part of the new Environment Bill that has got the most interest. But I'm going to start off with the really boring stuff. So what I want to talk about is not only part 1 of the Environment Bill, but actually chapter 1 of part 1. And the reason I want to talk about this is that this lays a new legal architecture for environmental law in England and Wales. So I want to give an overview of that, and I want to raise what I see as some of the risks in that framework. So first of all, I want to talk a little bit about why environmental law is important and what I see as its architectural nature. Secondly, I want to talk about the background to the environment bill. Thirdly, and this is the really boring bit, but it's important, I want to give you an overview of part 1, chapter 1 of the bill as it currently stands. I then want to highlight what I see as 3 risks or problems: that it creates a disjointed architecture, that it creates an executive architecture, and that it creates a weak architecture. And I want to highlight some of the risks that are raised from that. Now, one important caveat is I'm an academic, so I'm not a practitioner. I spend my days thinking about environmental law regimes in different continental countries, and that's the perspective which I came to this subject. Okay, the architectural nature of environmental law. So environmental problems are collective action. They are due to the fact that each of us as individuals contribute to problems, and each of us as individuals have adverse impacts on each other. They are socio-politically controversial because they raise questions about how we want to live. We can all agree that environmental protection is good. Very few people disagree with that, but what that means and what the implications of that raise socio-political conflict. Secondly, environmental problems need science. We need science to understand them, but at the same time, science is not. Thirdly, there is, because these are collective action problems, a controversial role of the state. The state is often needing to act to respond to these problems, but that raises issues about the legitimacy of that action. And this is where the architectural nature of environmental law comes into play. To begin with, in most regimes, what we see is legislation. Legislation setting out a stable framework for how environmental problems should be thought about and what action should be taken in relation to it. And that framework is created through legislative processes, which gives careful thought that once they're created as law, and that these frameworks are justiciable. But you cannot only have environmental law and legislation. There is also a significant role for public administration, whether it be at local government, whether it be national government, or even at a supra-government. Applying legislation, enforcing that legislation, and most significantly, assessing potential environmental impacts and making a decision about it. And finally, there is an important role for the courts. Okay, courts in dispute resolution, because environmental problems inevitably give rise to kind of socio-political conflict. There is a need for dispute resolution, but there is also a role for enforcement and also a role for accountability. And all this means that there is an interesting paradox in environmental law. We often think of it as the wild child subject of law. But in actual fact, environmental law uses all the institutional and legal resources of the separation of powers to operate. And that is particularly important. Now, let me just give you one, no, and we've got a problem with this moving on again. Fantastic. Just one very simple recent example of this about how this working legal architecture plays out. And this is from Australia, from New South Wales, very recent decision in the New South Wales Land and Environment Court, a judicial review case called Bushfire Survivors for Climate Action Against the Environmental Protection Authority. And the issue before the judge in that case, the chief judge of that court, Justice Preston, was whether Section 9 of the Protection of the Environment Administration Act required the New South Wales Environmental Protection Authority to pass policies in relation to climate change. And their argument was no, it didn't. But the argument of the group in that case is yes, it did. Now, what's interesting about this case is the legal analysis. So we see Justice Preston in this case go through in a very careful way through this legislative framework to show why the authority in needing to develop environmental quality objectives includes climate change. Not only that, but he also studies the nature of the Environmental Protection Authority and its own competence to show why it has to do that. Now, this case is in a sense holding this body to account. I think what's also interesting is they didn't appeal it. So here we have an example of a case where we see legislation, public administration, and the courts working in tandem. Okay, so that's the background. Let me now give you a background to the Environment Bill. So, environmental law really emerged in the early 70s, and although we have English and Welsh legislation, it is often said that 80% of UK environmental law, the substance of UK environmental law, is derived from EU law, and in particular directives, which are then implemented into national law through either legislation or, more likely, delegated legislation. Now, a thing to note about directives as forms of environmental legislation is they tend to be far more specific than you see, for example, in the United States or Australia. So that is where the kind of substance came from. And there has been an important role for both national courts and the Court of Justice of the European Union in implementing and enforcing that legislation. Likewise, there has been a role for the European Commission in bringing enforcement actions. So the question arises with Brexit, what becomes of environmental law? Now, of course, with the European Union Withdrawal Act 2018, all that law becomes retained law. And Professor Scotford will in a moment explain a little bit more about the role of environmental principles. But from very early on with the referendum, the question arose of what do we do from here? And what we see, particularly in bringing forth the Environment Bill and in the paperwork that accompanied the draft Environment Bill in 2018, were two different narratives. One was saying, we just need to fill the holes left by leaving the EU, in particular, the enforcement kind of role. But at the same time, there was something more ambitious going on. An argument that what was needed was to create a new legal architecture for environmental law in England and Wales. But again, these exist side by side. So what do we have? Okay, this is the boring bit, quite important. If we look at Chapter 1, Part 1 of the bill, and this is as it looks like as of the 15th of September, we see it has a number of parts. So to begin with, the bill in its original form had no overriding purpose. It now has Clause 1, which I'll talk about in a moment, which sets out its purpose and declaration, which is being about biodiversity and climate emergency. Clauses 2 to 8 give power to the Secretary of State to pass targets. So this is a new language, targets. It gives power to pass targets. I'll talk about them in a little bit more detail in a moment. There are also interim targets tucked into Clause 12. Clauses 9 to 16 talk about environmental improvement plans. These, again, are plans passed by the Secretary of State, which is setting out over a long term how the environment might be improved. And the 25-year plan is the first of these. And again, I'll talk about that in a moment. Clause 17 sets out details on environmental monitoring, although it's quite discretionary. Clauses 18 to 20 talks about policy statements on environmental principles. So the Secretary of State passes a policy statement about an environmental principle, and that should be taken into account by other ministers in certain circumstances. And clauses 21 to 22 sets out statements and reporting duties. So that's the overview. Okay, let me now move to the problems. And like an academic, I only have negative things to say. So the first problem with this is if this is meant to be a new robust architecture, it's incredibly disjointed. And I think Professor Scotford will be expanding on this as well. So at the moment we have Clause 1, and I'll show you that in a moment, which talks about the purpose of the Act is about climate emergency and biodiversity. But this is an Act also about air quality, about soil quality, about water quality. And how that is going to play out in practice, I don't know. Although it is good that the Act now has some kind of purpose. Secondly, there is no explicit relationship between the bill and retained environmental law. So the bill is using this new language of targets, but it's not clear how that relates to pre-existing environmental law as set out in regulations. You can kind of guess, but it's not clear. Thirdly, target setting. So this ability of the Secretary of State to pass targets is they must set a target in relation to particular topics, and there are more specific measures in relation to particular matter and species abundance, but it doesn't say how you pick the target. And finally, there is no environmental logic guiding the environmental improvement plans, and we'll see that with the 25-year plan in the moment. So the first problem is a disjointed architecture. The second problem is what I call an executive architecture. Now, let me be very clear here. I believe in the importance of public administration in environmental decision-making. I've written books on it. I think it's really, really important. So my argument is not that we should not have a role for public administration. The important point is that we need to think about how we constitute those institutions and how we limit them. And the feature of the bill is it gives a huge amount of discretion to the Secretary of State. Now, the hope is that it will be exercised well, but there's nothing in the bill that really guides it. So if we look at the short title of the bill, make provision about targets, plans and policies for improving the natural environment. Targets, plans and policies are not the working material of law. They each raise a question about what are the legal implications of these? How do they fit with law? And as I said, Chapter 1, Part 1 vests considerably power in the hands of the Secretary of State to articulate the norms, the environmental principles that are going to apply, the aspirations of environmental law, targets and environmental improvement plans, and the accountabilities. So what is monitored and what is reported is also in the hands of the Secretary of State. And this is largely in the form of discretionary powers over public duties. Many of the clauses starts off with the Secretary of State must, as he sees appropriate. So it starts off well, and then it moves on to that. Now, one would argue that this bill is modelled on political constitutionalism. The focus is on the Secretary of State and a kind of accountability, or at least a reporting to Parliament. But in being so, there's not a big role for law. Okay. Finally, a weak architecture. What do I mean by weak? If this is going to create a legal architecture for environmental decision-making, it needs to be kind of clear and it needs to set a clear direction. One of the features of this bill is many of the powers of the Secretary of State rest on a requirement to establish that there is an environmental benefit of acting. So rather than saying your goal is environmental protection, it says, well, you can set this target, but it should be that you can show that this will create an environmental benefit. So there is a kind of, before acting, you have to show that benefit. Now, anyone who works in the space knows often that can be very difficult to establish. Secondly, because there's little in the legislation, really the aspirations are those set out by the Secretary of State in targets and environmental improvement plans. And everything rests on particularly the Environmental Improvement Plan, which is a non-legal document. There is also little legislative obligation that is enforceable, because many of the statements are followed by if he sees it as appropriate. Environmental principle policy statements, and again, Professor Scotford will be talking about these, are really kind of, there are so many limitations in how they're formulated and then how they're taken into account. Okay, so let me just give you, oh, sorry, how do I go back, Josh? Thank you. Let me just give you some examples. And in a way, this bill is fantastic from a teaching perspective because it is so rich with kind of little legal questions. And I will come to that again in a moment. So this is clause 1. The purpose of this act is to address the biodiversity and climate emergency domestically and globally. But as I said, this bill is about more than those things, and it's not clear that there's much about globally in this bill. One would argue that actually, for example, the Climate Change Act would be better to have this kind of aim in it. But then look at 2. As soon as reasonably practicable, and no later than 1 month beginning the day on which this act is passed, the Prime Minister must declare that this is a biodiversity and climate change domestically and globally. And the government must have regard to this purpose and declaration. So it's the purpose, but also what the Prime Minister declares in implementing the provisions of the Act. Now, how that is going to play out if we're thinking about air quality and water quality, I don't know. Environmental targets, this is clause 2. The Secretary of State may by regulation set long-term targets in respect of any matter which relates to the natural environment, which is defined later in the bill, people's enjoyment of the natural environment. The Secretary of State must exercise the power in subsection 1 so as to set a long-term target in respect of at least one matter within each priority area. One matter. There's no limit on what matter. Could be anything, as long as it's in the matter. And then if we look at the process, before making regulations under sections 2 to 4, the Secretary of State must take advice from persons the Secretary of State considers to be independent and have relevant expertise. So it is for the Secretary of State to determine who they think is independent and who they have relevant expertise. And my favourite, in setting these statements, Secretary of State must be satisfied that the target or amended target can be met. So it's not about aspiring to environmental protection, it's can they be met. Okay. Just finally, an example of the Environmental Improvement Plan. So this is the 25-year plan, and I've just pulled from it the kind of, so if you read the bill, the plans sound like they're going to have lots of detail in them. But here we have the description of water quality. We will achieve clean and plentiful water. That sounds great. Improving at least 3/4 of our waters to be close to their natural state as soon as practicable. And there you see a kind of set of very specific targets and very vague targets. I won't go into detail, but my point is that is very unclear about what we are actually aiming for. Okay. So, what are the risks? And let me be very clear, I think these are risks for everyone. And what I've done in this section is actually pull out some of the comments from the written evidence as part of the bill process. And that material is really valuable, and I would encourage you to read it. So to me, the first problem is one about legal uncertainty. As the Mineral Products Association in their written evidence noted, businesses will always seek to maximise clarity and certainty. And the suggestion is, well, actually having these environmental improvement plans over long periods of time should do that. But if we look at the content of the plan, I don't see how it does. I don't see how the lack of clarity helps businesses understand what is the general direction and what is the level playing field. That legal uncertainty, I guess, is of interest to lawyers because I can see lots of potential legal disputes in this. But that's not really, when we're talking about a robust legal architecture, what we want. The second concern I have for this, and this comes from the British Lung Association, is the lack of a rigorous basis. So there is, in a sense, power for the Secretary of State to get information, but it's not a particularly strong duty. The monitoring, much of the monitoring is against the Environmental Improvement Plan. So the British Lung Association, the bill fails to set out what criteria or evidence government must consider when setting new air quality targets. The bill provides no meaningful, transparent role for independent expert health advice in government decision-making. And really ensuring that our environmental decisions are underpinned by that robust basis, which is recognising uncertainty is important. And as the bill, as it's currently framed, I don't see that. And finally, it's not fit for purpose. Client Earth, in their written evidence, describes the environmental bill is a landmark, that's not a bad pun, but kind of pun, constitutional bill. We might think of environmental legislation as a small c constitution. Coming back to the start of my presentation, what we see is that environmental legislation is creating a framework which manages decision-making and manages disagreement. How this bill works really, really matters. And this is a landmark. It is really important. But my concern is this disjointed nature, its executive nature, and in a sense, its weak nature might mean that it's not the constitutional bill that it should be. So thank you very much. There is the web. Can I encourage everyone to have a look at the Environment Bill and the associated documents? There's a lot of valuable information. I also have two articles of mine there. One is a comment I wrote on the draft environmental bill, and of course the bill has now changed, and a piece that I wrote a number of years ago on New Zealand's kind of framework environmental legislation. So thank you very much. I'll end it there.
Thank you very much. So, introduce Eloise Scotford, who at UCL, former colleague of mine, and again been at the heart of much of these developments in the environmental. So, Eloise.
Thanks, Richard. Thank you very much for having me to Landmark Chambers. It's lovely to be standing behind a lectern, I have to say. I am also obviously coming from an academic perspective like Liz. I will be critical like Liz. My take is partly negative, but I think really about complexity. And I am going to talk about the OEP, as Professor Fisher mentioned. I will get to that, but what I'm going to do is zoom out and look at the broader legal context in which the OEP is going to have to operate, and really the broader legal context that has emerged since Brexit. And this is where the complexity really comes in, trying to put together all the pieces of that legal picture. And in doing so, I'm focusing on a question of environmental ambition. To what extent do we see a legal requirement for environmental ambition, levels of environmental protection that are in any way ambitious in our post-Brexit environmental law landscape in the United Kingdom? And I'll be focusing on the bill quite a lot, but I'll also be looking at the UK more widely and comparing a bit with the Scottish legislation, the Continuity Act, which sets up their environmental body. So that's quite an instructive comparison. Oops. Okay, good. So an outline of what I'm going to do to zoom out before I come into the thinking about the OEP. I'm going to look at whether any kind of level of environmental ambition is legally required in the UK post-Brexit. And if so, a related inquiry, to what extent do we need some kind of common environmental governance across the UK? And against that background of what is required or what we might think is legally being legally constructed, what's the actual legal picture that's emerging through the bill and across the UK? And then I'll be looking at the OEP in that context to see what job it has to do and how it can fit within that broader context. So to answer that, try and answer that first question about are there any legal obligations for UK environmental ambition post-Brexit? The reason why it's complex is since October 2019, when we had the political declaration, if you can remember back to that, we've had many quite significant legal documents, agreements, moments happening, and they are ongoing because the green one in the middle, the Environment Bill, is going to be the Environment Bill 2019, I think, to 2022, a very long piece of legislation in its gestation. But we need to put together that with the Trade and Cooperation Agreement, the Protocol on Northern Ireland, the Scottish piece of legislation. We've seen a bit of what the Environment Bill might generate with the draft Environmental Principles Policy Statement that came out in March. Putting all of this together is a complex picture. So I'm going to try and disaggregate that and see through these different documents, is there anything about an aspiration or a requirement for environmental ambition in the UK post-Brexit? And I'm going to look at that in 4 ways. So is there a requirement to keep pace with EU standards? That's one way of thinking about environmental ambition. Do we need to keep pace with what the EU might do? And that presumes that the EU is going to be maintaining some level of environmental ambition in what it does going forward. But to the extent that it does, is there a requirement to keep pace? Now, the political declaration and following on that, the Trade and Cooperation Agreement makes clear that there, as a default, there is no obligation to keep pace. In the TCA, Article 391, the parties affirm the right of each party to set its policies and priorities and to determine the environmental levels of protection and the climate level of protection it deems appropriate. So that's giving regulatory autonomy to the UK and the EU. You can compare with that, though, one important development so far in the post-Brexit UK landscape, which is this piece of actual legislation. We have some real law which has emerged so far, which is fantastic. The UK withdrawal from the European Union Continuity of Scotland Act 2021, shortly known as the Continuity Act, which does not oblige the Scottish Government to keep pace with EU standards, but gives it the power to do so. And within their politics, there's certainly expectation that that power will be exercised. So that's one way of thinking about ambition. It looks like Scotland might be on a path for now for keeping pace with EU environmental standards, the rest of the UK not under a similar obligation at this point. What about taking account of other international standards, including EU standards? Is that required in any way? Well, the Environment Bill has a nod to this in clause 22, and here I'm using the same, and I hope, David, this time I have my clause numberings correct. I'm using the latest version, which is awaiting third reading in the House of Lords, which is the version that Professor Fisher is using. I think we're all using that version of the bill today. So clause 22, I'm pretty sure, sets out a 2-yearly process for the Secretary of State to report on international, which includes EU, environmental legislation that appears significant to the Secretary of State. So again, this point about an executive architecture. That's not very timely, but it's something that recognises that certainly in the UK reserved / environment, English environmental law space, that there will be some paying attention to what's happening beyond the UK. Again, the Scottish Continuity Act has something different. In section 13, it has guiding principles on the environment. And I'll talk a little bit about principles as I go through at various points. But those principles are defined and they are to be taken into account across environmental policy making in Scotland. They are derived from EU environmental principles. So there is a direct linking to EU environmental principles, and they're to be interpreted in light of EU developments around those principles. So that's another way in which environmental ambition is maybe impacting on the English Environment Bill and certainly threading through the Scottish context. Non-regression, that's another way of thinking about environmental ambition. This has been a real kind of political football in thinking about the development of the bill. Can the government give some commitment that there'll be no regression? And again, the Trade and Cooperation Agreement says something about this. And it says something quite interesting, which I think, again, is beyond my expertise, but means there is this real need now for environmental lawyers to work with or become trade lawyers. And that in a manner affecting trade or investment between the parties, and I know our chair has been thinking about what this phrase means, the EU or the UK, both parties should not weaken or reduce its environmental levels of protection or its climate level of protection. So that seemed to be some basic guarantee that environmental standards will not fall in either the EU or the UK post-Brexit. We look then to the Environment Bill to see if there's anything to match that kind of commitment. We have, which was the concession on non-regression, Clause 21. Clause 21 is, I mean, Professor Fisher's point about good lead questions for students, I mean, it's a very difficult provision to understand. It requires ministers who are introducing new environmental law after the bill to make statements about whether that new law will decrease the level of environmental protection provided for by existing environmental law. But that existing environmental law, as far as I can tell, is potentially hypothetical law because it's powers that might not have been exercised yet, or law that might not yet be enforced. So trying to understand what the baseline is of environmental protection against which that statement might need to be made is very complicated. And it goes to Professor's point about the executive nature of the architecture. It's trying to highlight that there's a baseline which is within the gift offered of the minister to decide at some point against which a drop in the level of protection might need to be assessed. So that's complicated. And then a fourth way of thinking about whether there are any legal obligations for environmental ambition in the UK post-Brexit is, well, what about future levels of ambition? In the TCA, we see something interesting on this, the Trade and Cooperation Agreement, which is a commitment to environmental principles. I mean, when in doubt of what the solution should be, put in some environmental principles. This is why environmental principles become very difficult to figure out what work they will do legally. But they do work well as high-level aspirations in political agreement / compromise, and you see them doing that work in the Trade and Cooperation Agreement. But each party does commit, the UK and the EU, to respecting internationally recognised environmental principles. Now, that internationally recognised worries me because there's not that many environmental principles that are recognised as creatures of public international law, for example. That doesn't, so we have to figure out what that means, to which it has committed. And then it lists what looks like the list of EU environmental principles that you find in the Treaty on the Functioning of the European Union, slightly adapted. So that is lurking there as something interesting and in the public international law kind of dimension. And if we get into the Environment Bill, what about future ambition in that respect?
Just
yes.
As we're on there.
Yes.
Just that phrase to which it has committed. I mean, what does that actually mean? Well, because obviously it's not saying each party commits to respect international recognised environmental principles. Stop. It's saying to which they're committed. And these principles are not necessarily in the treaty. They could be part of the national court or whatever. Are we committed because we just subscribe to the court? I don't know. Is that applies? I don't know.
I think it's difficult to understand. yeah, David, so many issues arising. It could be that this is the commitment in the Trade and Cooperation Agreement that was making some of this as a list. It could be that there, and I think in thinking about this, there was a lot of looking at lots of different multilateral environmental agreements, seeing that you might spot different principles in different agreements. So that makes more sense in the language to which it's already committed.
Yeah.
You could, I think you can argue that means a variety of things potentially, but yeah, it's not entirely clear. But anyway, let's get on. But I think that picture is really interesting, and I think that will continue to inform certainly discussion around how the powers under the Environment Bill should be exercised, that bigger context. Now, a related question, and it's kind of coming at the same question from a different angle, is, you know, taking into account that mixed picture on legal obligations for environmental ambition across the UK, there's another set of considerations or constraints around whether there's any common level of protection or common level of a common kind of framework of governance that's required across the UK. And there's at least 5 points here, and I think there's probably 6 points. And depending on which one you look at, you'll answer that question differently about whether there should be a common framework for environmental governance. So before I even get to devolved competence, there's obviously the shared nature of the environment in many respects, which is a tick for yes, that we might need to think about some kind of shared environmental governance across the UK. We have a shared natural environment. Devolved competence, the answer suggests the answer is no. And that's what we've had up until Brexit. Devolved competence in environmental policy has operated alongside the harmonising structure of the EU. And that's created quite a good balance for that devolution to work whilst addressing common environmental concerns. Then we might look back to the Trade and Cooperation Agreement. And what's interesting about that is if you look at the definition of environmental levels of protection, the ones that aren't meant to drop in matters relating to trade and investment, they are defined as the levels of protection provided overall in a party's law, which have the purpose of protecting the environment. Now, for the UK, that implies that we can say what are the levels of protection that apply in UK law. In some way, we can add up the picture and find out what that level of protection is. So we need to be able to do that somehow. And for the EU, it is defined. So it refers to the levels of protection common to all member states. But it does suggest that we as the UK as a whole need to be able to articulate some level of environmental protection. Multilateral environmental agreements probably push towards an answer. The answer to this question of whether we need common environmental governance should be yes, because we have common commitments internationally. Then we've got the very knotty Internal Market Act, and we could talk about this for hours as well. But what's interesting about this Act is that it makes provision for exceptions to its market access principles if they're instilled in common frameworks. Now, that has to be activated in the Act. It's not actually there yet as an exception. But it was agreed post-Brexit that this knotty problem, the fact that we have a joined up environment, but devolved competence, we lose the linking structure, the harmonising structure of the EU, we should put in common frameworks on environmental protection in various respects. And this commitment to the Common Frameworks Programme has had environmental policy or environmental areas at its heart since the beginning. And what has happened since the Common Framework Programme has got off, or has really started, and it's been slow starting, is that the environmental areas have been not addressed. So even in September, there's some provisional common frameworks that have come out, which seem to be largely driven by lorry drivers and driver's licenses and various things, which is not particularly that surprising. But there has been an increasing agreement to put environmental areas from active framework policy areas, where there would have been a common framework across the devolved administrations or the constituent elements of the UK, into the no further action basket, because apparently there's been agreement that no further action is required. And these include areas like natural environment, biodiversity, water quality, the EIA, use of the EIA directive, GMO marketing, which is particularly controversial in the context of the Internal Market Act. So there has been a desire to develop common frameworks, but a failure to deliver that. And then the Northern Ireland Protocol, of which I'm not an expert, but certainly highlights the fact that Northern Ireland status is exceptional in terms of commitments to environmental protection and levels of ambition due to the need to align with EU regulations. So let's turn to the bill. What is the legal reality actually emerging in relation to environmental ambition? And I think there's at least 3 layers. It's like peeling the layers of an onion to figure out what the level of ambition that's emerging is legally required in the UK. So first of all, if we look at England and reserved UK matters, we need to look at the bill. This is the first layer of the onion. Now, in terms of there being a level of ambition, I've kept this point in, which I had, despite the fact that Clause 1 now does have, as Professor Fisher highlighted, a new objective. There is no clear overarching objective relating to a level of environmental protection. And I think Professor Fisher's points are quite right, that it's a very kind of, it's an anomalous purpose for a bill that's crying out for an objective to have one that's focused purely on the climate and biodiversity emergency, as important as that is. It doesn't help with setting a level of ambition for the bill as a whole. Environmental improvement plans, Professor Fisher made the point that they have no environmental logic driving them. And I think whilst they aim for significant improvement, that's in the language of the bill, there's not a lot more that's driving the environmental ambition of the plans, and there's a real problem around baselines. Then there's the environmental principles that are in the bill. They've been much debated, much derided, much loved, but very confusing in the bill, because we have environmental principles in the bill, but buried beneath an environmental policy statement structure, which does mean that, well, they have to be proportionally applied. There can't be action taken that's disproportionate to benefit. There's lots of caveats, carve-outs, and of course the environmental principles policy statement is drafted by the minister, which we've seen the first vision of, and it's not very ambitious. So it's not doing the work that one might hope that it would do in setting, giving life to the environmental principles in a way that sets a clear, bright line of environmental protection in an ambitious way. The OEP, I think, is a hope here, because it at least has an objective which is focused on environmental protection and improvement of the natural environment. So the work that it has to do within this weak kind of and very open architecture, as Professor Fisher described, is it has a goal that is very squarely focused on environmental protection, and it can then inject some of that into the process and the administrative structures set up by the bill. So I think that's where you start to see the OEP having some real potential, and to enliven a level of environmental protection in English environmental law post-Brexit. There's a risk of regression in the bill. There is Clause 5 has a mechanism for lowering targets, lowering standards. In certain, there has to be a change of circumstances, but it's around economic costs being disproportionate to benefits. I think we've had lots of change of circumstances recently. You can see more coming. There's the chance of, and at the time this bill came through, I made this point a couple of times, there might be repeal of retained EU standards, and that was poo-pooed a lot as, oh, that won't happen. But see Lord Frost's review of retained EU law recently announced. There will be a review of all retained EU law to try and make it make more sense. So query whether we repeal some of the environmental standards we have inherited from EU law. And then whilst there's new target setting powers under clauses 2 to 4, there is, and again, this point that Professor Fisher made about it's hard to read the pre-existing retained EU law with the new standards that might come through or the new targets that will come through in the bill. But if you look at how they might be enforced, it looks like you get weaker standards through how they're enforced with the new kind of target setting under the bill. I'll come to that point. So the emerging legal picture, if we then kind of step back a little bit more, the second layer of the onion, is, and this is trying to align the comparable elements of the architecture under the bill and retained EU law, that really creates fragmentation in our English, certainly English environmental law. I'm conscious of time, so I won't go into this example in too much detail. We can talk about that in questions if you'd like to. And then there's a second layer of fragmentation, which is through the process of devolution. And what's interesting at the moment is we're seeing strong alignment with EU environmental law in Scotland and Northern Ireland, and the opposite in England and Wales. It looks like Wales, which their legislation has been delayed on environmental governance, but they're not as interested in alignment with EU environmental law as they have been in Scotland, but that's for a different reason as England. England is not interested in alignment because it just wants to do its own thing. In Wales, they have to fit within a pre-existing architecture of statutory goals for wellbeing and sustainable development under the Wellbeing and Future Generations Act and principles of sustainable management of natural resources under their Environment Act 2016. So they have a different architecture they have to work within, but that means probably it looks less like trying to align directly with EU environmental law. How am I going for time, Jeff?
Sort of 5.
Okay, great. I wanted to just highlight a little bit the picture in Scotland, because I think it's instructive before coming back to some final reflections on the role of the OEP, is we can see in this new Continuity Act, I think, a higher ambition for Scottish environmental governance. It's, in one sense, it's a narrower act. It doesn't have targets, doesn't have environmental improvement plans, but its provisions around environmental principles are much tighter. They're tied, as I said, to EU environmental principles. There's no policy statement that kind of dilutes their legal force. There's a wider scope of public policy making within the scope of the duty to have due regard to the principles, not just ministerial policy making. And then you look at how the functions of Environmental Standards Scotland, which is now operational, are set out. They're set out really clearly. And there is if you look at sections, we actually have sections, not clauses, which is very helpful, that won't change. Sections 20 to 20, section 20 mainly, of the functions of Environmental Standards Scotland. And it really gives equal priority to improving and optimising the overall effectiveness of environmental law as it does to dealing with non-compliance by public authorities. And that's really built into how the work of ESS is set up. And the kinds of powers it's given at the outset to deal with that. Very wide-ranging powers in the pursuit of having an effective body of environmental law, and that's missing from the Environment Bill. It has stronger enforcement powers, and this is, again, because it's looking at the effectiveness of environmental law generally. The failure to comply with environmental law, which triggers enforcement action, is worded differently, and I think the wording does provide a wider funnel to enforcement activity. And the force of compliance notices in Scotland compared with English decision notices is stronger, and they don't need the environmental review mechanism that Tim is going to talk about, because you can go straight to the Court of Session and enforce a compliance notice. So what's the role of the OEP in this context? Looking at the functions and the powers it does have, it's got these powers on monitoring and advising in environmental law. And I think because of the complexity of that background, those powers become really, really important. It has a job to reporting on environmental law. And I think that must include, considering the landscape we're in, reporting on how environmental laws, retained, pre-existing, new, are working as a coherent body of law to support environmental protection and improving the natural environment, which are its goals. Also advising on changes to environmental law. There's a discretionary power to give advice to ministers on any changes to environmental law proposed by a minister. And I imagine that would be a really important power for the OEP in pursuing its principal objective, exercising that power. And finally, on enforcement, and I think Tim will pick up on more of this, but the OEP has a role in enforcing all environmental law. Everything will fall into that basket, but only if there's a failure to comply with environmental law, and that failure is serious. Now, the definition of a failure to comply with environmental law is really important here. It's one of my bugbears. I think it's very awkwardly drafted, and it has a real potential to cut off some compliance, some enforcement action. But more importantly, the precise construction of that underlying law. And that's why the fragmented picture really matters. There's very different kinds of obligations in environmental law. And then figuring out what those obligations are and whether there's a failure to comply with those obligations is going to be quite an important task for lawyers, legal practitioners, and I think it's going to be quite different and difficult in different cases in relation to different parts of environmental law. And I think that's because, and I've put here, the precise construction of that underlying law will be very important. There is lots of different kinds of environmental regulation. There are obligations on private operators, which is a lot of the bread and butter of environmental law, permitting, licensing, planning, consents, and so on. There's lots of obligations on ministers and public authorities to regulate those private operators, to achieve environmental outcomes. Think air quality, water quality, which is what I spend a lot of time thinking about on air quality. To take into account considerations in decision-making, to undertake various processes in environmental governance. And all of those obligations on ministers and public authorities are the concern of the OEP. There's a big question around environmental review is a big stick in enforcing those obligations, and I will leave that to Tim to talk about. But what I wanted to finish on, and to make this point about the importance of the underlying obligations and how they actually, the detail of the legislation, will be a big part of how much work the OEP can do in expressing an ambitious vision around environmental protection through its enforcement powers, is this is the tricky provision, clause 32, of what a failure to comply with environmental law is. 2A and B are the critical provisions. Unlawfully failing to take proper account of environmental law in exercising its functions, and unlawfully exercising or failing to exercise any function it has under environmental law. And I think an interesting test is, well, what about meeting targets under the bill? Now, under the bill, there is target setting powers, and as I mentioned in clauses 2 to 4, and in clause 6, there's a basic legal duty on the Secretary of State to ensure those targets are met. At the moment now, that's slightly messy because that in the Lord's amendments includes now duty meeting interim targets. So the minister has to ensure targets are met. Now, if the minister doesn't ensure targets are met, which is probably going to be quite a long time period, but if they don't ensure targets are met, is that unlawfully exercising any function it has? Because meeting a target isn't a function, it's an obligation, it's a requirement. So it's awkward language. Now, I think good lawyers will make arguments about this and say it's a legal obligation. Absolutely not. You can make the argument that it's not straightforward language. And what complicates it in relation to targets is clause 7, which follows, which sets out the consequences for failing to meet a target, which is a reporting duty. So the minister has to go to Parliament and report on why the target hasn't been met, and set out steps to ensure standards are met as soon as practicable. Now, that doesn't suggest that the minister gets in trouble necessarily for failing to meet a target. It's just whether they report on steps to meet that target as soon as practicable. Again, how does that link to clause 32? What would the OEP do in this scenario? What's it going to do in the time between when the target is set and when this reporting moment happens? And I think all of that is a nice legal puzzle and not entirely straightforward. But I will stop there.
Thank you very much. Just ask you, I think metaphors about onion skins are very dangerous at the moment. Pretty Patel is having the same one about Tibet. Oh, she says the more skin she unwraps, she cries even further. So I don't know if that's happening to you. Just before I introduce Tim, I'm just going to, if I can do my technology here. There's one comment just to, I think, sort of bear in mind, this is an audience of people who are practicing either law or planning or whatever on the ground. Somebody said that it seems from Professor Fisher's comments, and probably Eloise as well, the bill is almost too vague to serve its purpose. Yes, but that is what we're likely to end up with. We don't quite know. There are 1 or 2 amendments in the Lords, but this is what we're faced with. So what do we do to make the best of it? And I don't really want to say anything now, or just to give a little break in the speaking, or just bear that in mind. You know, this is what we have, and in a sense, you know, I feel that this is what we have.
Can I answer that? Is this working, Josh? If I talk into this?
Yes, it is.
Okay, so thank you for that comment, and it's an excellent one. So it seems to me that there are 5 things that need to be done. The first is a logic of this bill, as I said, is about political constitutionalism. So a lot of work needs to happen in Parliament through MPs and through ministerial accountability. And one could argue that if we look at planning, the proposals of the planning white paper, that can be quite interesting, what happens with that. So that's the first thing. The second thing, and Professor Scotford has already highlighted this, and I'm sure Tim will highlight this, is the OEP becomes incredibly important. The OEP can not only enforce, but it can also kind of do some monitoring. Thirdly, there are bits of this bill that I think are really important to enforce. So if we look at clause 5, 3 and 4 about making sure that targets don't lower anything and relating that to retained environmental law, that's going to be important. Making sure that clause 7 in relation to reporting works, and so on. Now that is probably going to result in litigation. There is also an independent role for monitoring by civil society and by others. And finally, and I would just note Richards and the Environment Agency from, I think, the 15th of September this month, we're seeing a new kind of case law with the role for kind of rights. Now, the reason I highlight all of this is because it highlights that it doesn't matter, you know, whatever framework there will still be an important role for law. A better framework is one that accommodates those legal disputes, it creates more legal certainty about those disputes, than one that kind of, you know, in a sense doesn't accommodate it. So then you have, in a sense, parties looking elsewhere. Thank you.
Okay, thank you very much. Okay, and the only other observation I would make is that it does seem to me it's one of the features of quite a lot of modern legislation, and I'd include the Climate Change Act, that a lot of the provisions are actually not about sort of legal responsibility through the courts, but about legal accountability to Parliament, particularly. It's the point you made, where, you know, you're requiring the minister to make reports to Parliament every so often. So, and that's a difficult one. And I also pick up, and maybe David's got some thoughts about this, the point you made about the targets and then having to report. You have exactly the same conundrum in the Climate Change Act, where both the interim and the targets appear to be absolute targets. The Secretary has to reach that target. And then the next clause says, if he can't reach the target, he has to report to Parliament why and what he's going to do. And my question has always been about that. You know, if David was bringing that case in 2049, if you're still there in 2050, would the court say, well, sorry, no, it's clear that he's responsible to Parliament for his failures. You know, that's what the legislation says. Or are the two compatible? I think they're probably compatible. Sorry, but I'll get you on to the. I'm not delaying you to get on to the OEP. No.
Can I just add to that? That this is why the point about kind of pre-Brexit or retained EU law and this EU law is really important, is because under retained EU law, and the way it was enforced, it had much harder edges that could be more directly enforced in court. And so it is, while we're kind of uncertain about how to enforce these new targets, we come from a background of having some quite hard-edged targets that resulted in very powerful litigation.
Yeah.
And so it's a bit more complex. Yeah.
Okay.
Oh gosh, Tim.
No. Let's not. Come on, we're all
okay.
going. No. I'm going to introduce Tim. Long last. Who is going to talk about the OEP, I think, in particular. So I will be taking a lot of notes. But Tim, I'm going to be over to you. I hope we can end this session on we'll see how the questions are, and sort of touch of optimism.
Well, let's see. I don't know if I'm going to be bringing litigation in 2049. That sounds quite ambitious, but anyway. So I'm going to be talking actually from slightly more from a practitioner's perspective. So, of course, I will therefore be negative and critical. No way to say. But what it does mean, perhaps I'll be drilling down into the detail of the provisions and how they might work in practice a little bit more, the wording of the legislation. First thing to say, so the first thing to say is just, and others have touched on this, I'm working from the latest version of the Environmental Bill, which is post-report stage in the Lords, pre-third reading in the Lords. That's particularly important to my talk because, as we'll see, in particular in one area, there's been a change since the last version. But it's also important because That may not be the final version. It's got to get, but those, especially the amendment I'm quite interested in, has gone. It's very controversial in the Lords. It may get reversed by the Commons, so we'll have to see what happens with that. That does make another point. Richard made the entirely valid point that, of course, to some extent, we've got to deal with the bill that we're getting. This is what we're going to be getting. But to some extent, that's not quite set in stone as yet, because the bill is still a bill. There is still a possibility of amendment as to what we finally end up with. Whilst I'm on this slide, I haven't said it on the slide, the other thing to be aware of, but I don't think it's that exciting, is that there has been a consultation on the rules in the CPR that will be applied to environmental review. I think we're still waiting for results of that. It ran from July to September. But the broad tenor of it was that environmental review is going to look very like judicial review. So there's not going to be any major surprises. There'll be points of detail, but I don't know that anything desperately exciting is going to emerge from that. All right, so I'm going to be talking about the enforcement functions then of the OEP, especially environmental review. We can't really talk about environmental review without talking about the other enforcement functions. So we've heard from Eloise that the OEP has its monitoring and advisory functions. This is focusing just on those enforcement functions and how it has to force public bodies to take action. All of those enforcement functions then, see clause 32.1, relate to failures by public authorities to comply with environmental law. The definition of that's important. Eloise has already said something about it, and I'll come back to it in a moment. And in relation to that, it has three main enforcement functions. First of all, consideration of complaints and carrying out investigations. Secondly, bringing proceedings for environmental review. And then thirdly, and separately, bringing its own claims and intervening claims for judicial review. The first two of those are interrelated because they go together. The environmental review stage only happens at the end of the investigations and complaint stage. The judicial review stage is slightly separate. The other thing to draw attention to on this slide, though, again touched on by Eloise, is that what we're dealing with here in relation to the OEP is failures by public authorities. So the OEP is not an organisation. It's not a regulator in the ordinary sense. The main environmental regulator in the UK is, of course, the Environment Agency, and to some extent, for example, planning authorities and bodies like that. They're the bodies that deal, for the most part, with private entities, companies, making sure they carry out their own activities in ways that are compliant with environmental protection. What the OEP is concerned with is whether those regulators and ministers and bodies of that kind are themselves complying with their environmental obligations, as they are. Okay, so those are the enforcement functions of three kinds. So we start with complaints and investigations. The way I'm going to do this, I'm going to talk about the basic structure of the complaints stage and then the environmental review stage, so we see how they fit together. But then I just want to come back and talk about some of the issues of controversies, which I think are most important. So complaints and investigations. So members of the public may make a complaint to the OEP concerning an alleged failure to comply with environmental law. That sounds, it's interesting, the OEP, what the government says is the OEP is a body which was designed to fill the gap that was left by the removal from the scene of the European Commission, which used to exercise the power of ensuring that national or nations, basically member states, were compliant with their environment. It's not clear, though, that the OEP really does is in a position to fulfil that kind of role, fundamentally and structurally, because in fact the OEP is not a supranational national body. It can't, by definition, it can't look at the way in which the UK as a whole is complying with environmental law. What it's going to be concerned with is something more granular. Are individual public bodies within the UK doing their bit primarily under national law, not whether the UK is complying with it. So anyway, that's the basic way in which an investigation will be initiated, maybe via a complaint by a member of the public, or maybe, of course, an environmental NGO. But then either pursuant to such a complaint, or I think very importantly, and certainly if the OEP is going to be this kind of strategic body the government has talked about, also of its own motion, the OEP can then carry out an investigation in relation to possible alleged putative failures to comply with environmental law. And that's done under clause 34. There's not a great deal of detail about how that occurs. but as I say, it's important the OEP can carry out its own investigations without one complaint. And then the process that follows on from that is further delineated in clauses 35 to 37. Most notably, I think it has power to seek information from the the bodies of which it's making a complaint and to require them to give that information. So that's complaints. And then if it finds that there has been a breach of environmental law and that the failure to comply with the breach is serious, it can then issue a decision notice. So a decision notice is only issued where it's identified a failure to comply. If it finds that there wasn't a failure to comply, it doesn't issue a decision notice. And a decision notice, the effect of it is to, first of all, describe the failure to comply, explain why the OEP considers that the failure is serious, so that's why effectively it's issued the notice in the first place. But then importantly, and this is the only remedy in the real sense that the OEP can give, set out the steps that the OEP considers the authority should take in relation to the failure. So in other words, set out, which may include steps designed to remedy, mitigate, or prevent recurrence. So in other words, what it can do is say, this is what you did wrong, this is what you've got to do to make up for that, to prevent it happening again. But importantly, note the limitations that will come back to this. The OEP recommendation is non-binding. The public authority doesn't have to follow it. There are some detailed provisions about the authority has to publish reasons why it won't comply and so forth, but it's not required to comply. And secondly, and this is very important, I think this is often missed, the OEP does not have the power to set aside, quash or undo the action in question, and by the same token, nor does it have the power to recommend that the public body should itself undo or quash the decision. And that means what it can't do is undo the consequences of past failures, and I think personally that's a very important step to the way this works. So that's the complaints and investigation stage, comment in a decision notice. We then go on to the environmental review stage. As I say, the environmental review stage then only comes at the end of that process. It's not a freestanding process. And clause 39(1) provides the OEP to apply to the court for an environmental review, which is in broad terms a formal judicial review. It's going to happen. It looks like in the court. The basic procedures are going to be very similar to judicial review, except of course that because it comes at the end of that process of investigation, it's going to be taking place at a much greater distance in time from the action to which it relates, the alleged unlawful conduct. And so the subject of that application, and this again is very important, is the conduct to which the decision notice of the investigation relates. That's important because what the court is not doing is looking to see whether the public body's response to the OEP or response to the OEP's findings is lawful or appropriate or anything of that nature. It's looking back to the original conduct in question and simply deciding whether that was lawful conduct in judicial review or in public law terms. And so the role of the court is there making that point is specified in clause 39(5). On an environmental review, the court must determine whether the authority has failed to comply with environmental law, and I have underlined applying the principles applicable on an application for judicial review. The remedy, two critical remedies. First of all, a statement of non-compliance, i.e. a statement that the public body didn't comply with the law. And secondly, where such a statement has been made, it can also grant any remedy available on judicial review, subject to, and I'm going to come back to this, which is a really important point, subject to certain limitations relating to prejudice to third parties. And the public body, as well as complying with any enforceable remedy, so quashing order of that or something of that kind, the public body must also publish a statement as to the steps it proposes to take. But again, there's no comeback to that. It publishes its own response. There's no further action the court can then take to enforce that if it's not happy with the response the authority gives. So that's the basic structure of investigation.
Sorry, make sure you use which microphone is working. I've just got a comment.
Sorry, apologies.
I think it's the handheld one, is it?
It's this one. I'll do my best.
Which one? That one. Yes,
right,
okay.
okay.
Could you make sure you speak into it?
Sorry about that. Right, okay, we'll do. So that's the basic structure. What then what are the kind of points to tease out about that? Well, the first relates to the definition of failure to comply with the environmental law, and Eloise has already touched on this. So, and I think she sent this out on her slides as well. There's a curious definition. A reference to a public authority failing to comply with environmental law means the following conduct by that authority. A, unlawfully failing to take proper account of environmental law when exercising its functions. And B, unlawfully exercising or failing to exercise any function it has under environmental law. What it doesn't say, I'll try the pop style method. Is that better? What it doesn't say is that it's a failure to comply with environmental law if you fail to obey an environmental law obligation, a mandatory duty. Now that I think is the same curiosity that Eloise was picking up on. And so curiously, the most obvious sense of a failure to comply with environmental law doesn't seem to be captured by the definition. On one view, you're actually narrowing the natural meaning of failure to comply rather than broadening it and missing out the most important obvious thing. Now, there may be an answer to that. I can well imagine lawyers arguing, probably successfully arguing, that by definition, a failure to comply with a binding duty is a failure to take proper account of environmental law, for example. That seems to be the obvious answer, but it's a very strange definition. The other thing which I think is really interesting about this, though, relates to the role of the OEP. So what is the scope of the OEP's consideration of environmental law? In other words, when the OEP is carrying out its investigation, when the OEP is deciding has there been a failure to comply with environmental law, is the OEP itself limited to applying an approach which is akin to judicial review? Well, on one view, it would be, because anything short of that wouldn't amount to a failure to comply with the law. Or does the OEP have a wider role of carrying out its own fact-finding? Can it reach a different view of the underlying facts and therefore take the view that from the public body which has had the primary duty, and therefore take a different view on how what action was appropriate or what the law required? Can it take a wider view than a judicial review court would do of what amounts to taking proper account of environmental law? It's not clear, and I can see problems both way around. On the one hand, if it's limited judicial review, that gives the OEP quite a limited role. This is, after all, an expert body. You would expect it to have a wider role after carrying out a detailed factual investigation. On the other hand, the other extreme seems to be that the OEP would effectively usurp the function, and that carries its own problems. Now, whether there's a middle ground, I don't know. It seems to me there's a difficult issue there. And then that in turn raises a final point about this, which is again about the relationship between the OEP own process, the complaints and investigation stage on the one hand, and the environmental review stage, because it doesn't look as though the environmental review court, applying judicial review principles, can carry out a factual investigation. And so it may take a different view, may be bound to take a different view from the OEP of whether there was a failure to comply, because it's effectively exercising a different kind of role in relation to the primary facts. So that's the first area of doubt and uncertainty. Seems to me to throw out some problems. The second area I want to draw attention to is what I would regard as the mismatch between the OEP's remedies and the environmental review remedies. So, as I said, where it finds a failure to comply with environmental law, the OEP issues a decision which must explain the nature of the breach, why it's serious, etc., and, critically, set out the steps which the OEP considers the authority should take in relation to the failure. So that's a forward-looking thing. What the OEP can say is, well, you might pay someone some compensation, possibly, or you might, more importantly, do X, Y, and Z in order to make sure that you don't make this kind of mistake in the future. It's not about correcting, not on the face of it, about correcting the wrong which has already occurred. And in many cases, it will be impossible for the OEP even to recommend action of that kind. Why do I say that? Well, because importantly, it's under the second bullet point under limitations. Public bodies are generally functus officio once they've taken action. They can't, without the quashing order of the court, they can't undo the thing. So, for example, they can't withdraw the planning permission or the environmental permit or something of that kind. They can't, and therefore any OEP recommendation to do that will be meaningless, because they won't have the power to obey the recommendation, even if they wanted to do so. Now, that's an understandable model. It's not necessarily problematic, But what you then put it alongside is what happens at the environmental review stage, because the court in an environmental review, its power is to grant and only to grant judicial review remedies. So the classic judicial review remedies, of course, a quashing order. It undoes the thing which is found to be unlawful. So it quashes the planning permission, it quashes the environmental permit, it carves out the bit of the local plan which is said to be unlawful, whatever it may be. And it has no power at all in relation to the future. It has no power to recommend what steps the authority should take. And critically, it has no power to enforce any recommendations the OEP will make, which will almost by definition have been different in nature. And so what you end up with is, it seems to me, a real mismatch between what the OEP can recommend by way of remedy on the one hand, not enforceable, well, that's not binding rather, that's understandable so far as it goes if there was then a power to apply to the court for enforcement. And on the other hand, the Environmental Review Court, which can do something completely different. And in practice, it seems to be going to potentially undermine the efficacy, attractiveness of both procedures. So think if you're a potential complainant, you're an NGO, let's say, you're concerned about some particular action taken by a particular public body, you think it's acted unlawfully. What you almost certainly want to happen most of the time is for that action to be quashed so that so the body is obliged to think again and act differently. Well, in principle, you could get that, but only if you succeed in your complaint to the OEP finds that there has been a breach, and the OEP is then, notwithstanding its inability to recommend the thing that you want, is then also willing to take the case on environmental review. In practice, that's going to make it a very unattractive procedure and one that NGOs may not choose to use. Suppose, on the other hand, you're the OEP, you carry out, or you're possibly a campaigner who is concerned with future action. You carry out your investigation, you reach a complaint, no doubt the OEP will go that far when it's up to them, and it makes a series of recommendations, and it's then faced with a recalcitrant public body which is not willing to obey the recommendation, to follow any of the recommendations it has made. Well, there's nothing the OEP can do about that at that stage by way of environmental review, because what the court is going to be concerned with is not compliance with the OEP's recommendations, but simply with whether the original action was unlawful, something that the OEP has already made a conclusion on, and the OEP may not be concerned to see the action, the particular decision quashed. So I think there's a mismatch, which is potentially going to undermine both of those procedures and the attractiveness or utility of both of them. Third point, and this is the point where what I said at the start about the changing versions of the bill becomes very important. The last version of the bill, but one, contained a very important restriction on the grant of remedies in environmental review, and what was then clause 37.8 is now in clause 30, the relevant equivalent bits are now in clause 39. And it said that the court could only grant a remedy where it was satisfied, and that would include a quashing order, for example, where it was satisfied that it would not be likely to cause substantial hardship to or substantially prejudice the rights of any person. I think that the cut-off is other than the authority, or where it would be detrimental to good administration. Now, that will, to public lawyers, that will look familiar. It looks quite like the restrictions in the Senior Courts Act, section 31, on the grant of remedy in judicial review, but there's a critical difference, because in the Senior Courts Act, in general judicial review, the limitation is that if there has been delay in bringing the claim, you can't grant a remedy, or you may choose not to, at this discretion, you may not grant a remedy if, and then it's the same stuff, it's hardship to third parties, etc. But this is, although somewhat familiar, in fact, it's a very different provision because it's an absolute rule. You cannot grant a remedy if there would be any prejudice. And as many people pointed out, that would, in practice, if that finds its way into the statute book, that would mean that the Environmental Review Court would, in practice, almost never be able to grant certainly strong remedies, for example, like a quashing order. Why? Well, think about the Planning Commission, think about the environmental permit, obvious for them. You're the third party who's got your, let's say it's an environmental permit to emit such and such emissions from your factory. It's found that it was granted to you unlawfully by the EP and then subsequently by the court. The court It's about whether granting a remedy, quashing that permit would cause any prejudice to anyone. Well, obviously, it would cause prejudice by definition. But it's not just in relation to that case. It's also very likely to apply to any case, almost any case one can think of. So think about an environmental policy, an improvement plan, a local plan, anything of that nature. There will be particular operators who will be able to say, we relied upon the version of this that was issued. It would not in the obvious way that would lead our practice, but it would prejudice our future plans if we're not able to rely upon that in the future. There's going to be some slightly generous provision from our perspective, and therefore it would cause and substantial hardship if that were to be overturned. Therefore, the court has no discretion about whether to grant a remedy. Now, that, as I say, is not it now in the bill as it stands. You may say, well, why am I banging on about it? On one level, it's because I've had quite a long involvement in this. In the original draft bill back in 2018, there was no restriction. It was all the other way, right on the other extreme. And so we've kind of gone around the houses, and it's an ongoing thing. But much more importantly is, this was a very controversial amendment in the Lords. It's not at all clear it's going to survive to find its way into the statute book, so it is an important issue. What we've got in the bill for the time being is a much more discretionary provision. The court is required to have regard to prejudice. That seems to me to be an unobjectionable provision. But watch the space, as I say. Last point, what about judicial review? Well, the OEP's third enforcement power is the power to bring judicial review, but importantly, it's limited to judicial review in urgent cases. So the restrictions on the OEP's power to bring judicial review are, first of all, there must be a failure to comply with, in its view, a failure to comply with environmental law. Fine. No point to bringing it otherwise. Secondly, it must be serious. Well, you can argue about that, but one can understand the government wants the OEP to limit itself to the bigger cases, as it were. But thirdly, it must conclude that making a claim for judicial review is necessary to prevent or mitigate serious damage to the natural environment or human health. And that's called, in the legislation itself, that's called the urgency condition. Presumably the idea of calling it the urgency condition is on the basis it limits judicial review to urgent cases where the environment, etc., process is not appropriate or available. Don't think it does quite work like that, because it would appear to leave judicial review open where the OEP concludes that the investigation process, etc., process is not appropriate, not only because it won't be quick enough, but also, for example, because it thinks that the court won't grant a remedy at the end of the day, for the very reasons we're discussing around the mismatch between the investigation and environmental review remedies, or because of the limitation about hardship or something of that kind. Anyway, it is nevertheless quite an important limitation on the OEP's power to bring judicial review. And importantly, because it's restricted to cases where there's a failure to comply with environmental law, it looks like, and again, clever lawyers may find ways of arguing against this, but it certainly looks like, again, judicial review can't be used to enforce the OEP's recommendation. So an individual who gets a recommendation as a result of the investigation, they may be able to bring judicial review to enforce the compliance with the recommendation. Who knows what principles the court will apply, but it's at least possible. But the OEP has no power to bring that claim. And again, it's left without any means to enforce or, pursue its own recommendations where it's not satisfied with the response to them. Final thoughts, what does all of this mean for the effectiveness of the enforcement powers? Well, there are some significant powers here. I don't want to be totally pessimistic about it. It'd be very interesting to see how the OEP exercises those powers. Plainly, some part of what the effectiveness of all this is going to depend on political will of the OEP. Catch Richard's eye as I say that. And also, very critically, on the resourcing of the OEP. But as I say, for the reasons I've set out, I do think there are some structural problems with the powers the OEP has been given, which may impose some restrictions on the way it can exercise those functions. Thank you very much for listening.
Thank you very much, Tim. Again. Oh, brilliant. We've got a print out of questions, which are mostly about sound quality. But that's very helpful. And could I just remind people, I know there are about 16 chats. I can't read the chat. So if there's a question, put it on the chat. Could you put it back on the questions too? Can I take, is there anybody at the moment in the audience who's got a question to ask either to all the panelists jointly or on any particular point that's been raised so far? Yes, there's a question. And could you just identify yourself as?
Yes, thank you so much. I was through presentations. I have 100 questions, but I'm only going to ask one. My name is Belinda Jack. I'm a practitioner, and I'm also a legal drafter. I drafted legislation on the environmental investigation. When you mentioned the United Kingdom's legal obligation, I just wondered if you might be able to say a bit more about international legal obligations. For example, the word ambition always necessitates Paris Agreement. And I wondered whether that features at all under this new legislation, what effect it would have, and also whether there's a good faith obligation under international law for the UK to take that into account, or the courts pass when they're interpreting this legislation.
And could I just add a rider to that, because it really interests me, and I've written about this, that it's always seemed to me, I mean, obviously, the EU legal system provided a kind of underpinning basis. And it also, although the UK has ratified, I think, about 40 international environmental treaties, many of those the EU had also. And so a lot of our kind of international obligations were disguised EU implementing things like the habitat regulations. So I'm also intrigued about the extent to which post-Brexit, and maybe the practitioners here could also answer, do they see, although we still operate a dualist system, that's been reinforced in international law, which has been implemented national law, we can't really raise it. Do you actually see in practice at national level, there will be more opportunities to raise international environmental obligations? And you were touched on that. So I'm just, maybe that's a sort of rider to your question, because I think it's a very interesting question generally.
I will have a go at this first. Thank you, Melinda. I hope the audience heard that question as well. Josh, will they have heard the question? Great. I mean, I agree with Richard that this is a really interesting kind of legal space that's opened up post-Brexit, because we've been able to kind of ignore a lot of the requirements of international environmental law as they've been delivered through EU law. Now, for as long as we've got retained EU law, we've still got some bite from those international kind of filtered through EU law obligations. So that's kind of important to begin with. But to the extent that they get changed or international law evolves, or some of those international law obligations were not yet part of EU law or UK law, I think that space is going to grow about the UK's compliance with international obligations. We know it's a problem with Aarhus already. We know we've got a compliance problem there. I think the Plan B case, or the Friends of the Earth case in the House of Lords, went the other, is not cause for a lot of hope about the extent to which what Richard is suggesting, that international law obligations will shape reasoning in the domestic courts without there being domestic implementation. What I can see potentially, and this is where the open architecture of the bill, for example, in England could be quite interesting, and again, Professor Fisher's points about political constitutionalism, is are those powers exercised to be consistent with the demands of international environmental law? That could be part of the political discussion and conversation. And I note again, if I come back to the role of the OEP and ESS, and I pointed out section 20 of the Scottish Continuity Act, which talked about the powers of Environmental Standards Scotland. And one of the things that it is actually tasked with, or has powers to do, is to keep under review implementation of any international obligation of the United Kingdom relating to environmental protection. It very explicitly has that as one of the things it can do. And it's suggesting that it should do it by having that power. And I think the OEP can do similar, even though it doesn't have it spelled out in the legislation in the same way. So this is kind of Professor Fisher's point about the whole ecosystem of the administration that's set up can bring in these points, even if they're not directly legally applicable, and do something interesting with them. Yeah.
I'm going to be provocative, which is that when we're talking about international environmental law, and what I mean here is public international law, not EU law, is actually it's quite limited in what it covers compared to what kind of environmental law we need here in England. So the notion that we look to it for our answers, we have to be very, very careful with that. Just as we need to be careful with this idea, and this relates to a question in the chat, about we think, oh, isn't it great that we now have these targets? But as we can see from the bill, many of these targets are not actually legally enforceable. So I think what I would say is, in a way, what we need to focus on is this legislation and the robustness of this legislation. And there was another question in the chat about the wonderful complexity of nature conservation legislation. And that is an example where the complexity of some of it does come from international law, some comes from EU law, much of it comes from national regimes. It's working that out within the national setting, which is important.
And I just want to, I'm sort of David Elvin sitting in the front, so I don't know why I was already, I shouldn't be including you, but you know, as a practitioner, and if you're advising on, in a national context on island interpretation, you know, are you tempted, or do you feel yourself more, well, maybe I should just check any international conventions, I might be able to bring them in my arguments this way, if you feel that's going to be more of a tempted, or you're back to rather.
You might well want to look, but I mean, the only thing I was going to say is that my sense is that it's still reduces rather than increases. I mean, one very, and of course that's alongside in a long part of the review. One very clear example is you touched on in relation to the environmental principles, which are the effects of which we're told it's clause 20 of the bill. And it's not just that they're diluted in the sense of the minister gets to issue a policy statement telling you what the environmental principles mean or how he's going to obey them. But the only effect of the environmental principles now is that, clause 1, the Minister of the Crown must, when making policy, have due regard to the policy statement on environmental principles. So ministers have to have regard, but courts no longer have to bring them into their interpretation of legislation. Other public bodies, all of those other public bodies, including the Environmental Agency, regulated by the OEP, regulated by the OEP, they don't have to have the entitled to be touched in some sense. So it seems to me this goes.
Okay, I'm just looking at any. Yeah, sorry, yes.
Something I raised just in that context. I'm going to be speaking a bit more about the ecological protections this afternoon, so I'll save a lot of it for there. But one of the problems with the definition of environmental law, which you highlighted this morning, and the clause 21, is it only applies to bills. And one of the characteristic elements of this legislation in all its detail is virtually every other provision has provision for regulations and statutory guidance from the Secretary of State. The nature conservation, the 3 new strategies we'll have under Part 6 and various others, including Biodiversity Net Gain, so much of it is to be dealt with by detail. So what the state of environmental law is under clause 21 when the minister comes to make a statement is very much going to be in the control of the minister. And it's not just an onion; it's onion and cotton wool, because you've got layers between the statutory principles. Then you've got the regulation-making powers. Then you've got duties to have regard about the weakest duty you can come up with, and then finally you've got statutory guidance emanating from the Secretary of State in a whole plethora of cases where there are going to be documents after documents, and on top of that, as I'll mention this afternoon, you've got the new duty in relation to the general biodiversity objective under section 40 of NERCA, which public authorities are going to have to apply in the context of the new ecological strategies. So it's not an easy landscape to view just looking at the bill. But I agree with Tim. I don't think international treaties are going to come into this at all. Clause 22 very firmly puts that in the province of Parliament, not in the province of the OEP or the courts.
Okay, well, thank you very much. That's very good. There's one question I think I can answer. Yeah, anonymous. Will the OEP be able to enforce against the devolved administrations? Well, as always, the answer isn't quite that simple. But basically most environmental matters are devolved. So the OEP will not have jurisdiction against Scotland, which has got its own body, Wales, which is still developing. The legislation provides that if the Northern Ireland Assembly agrees, then the OEP can have jurisdiction in Northern Ireland. And the Assembly has not yet agreed. I think the feeling, and again, this is, sorry, I'm going to be talking privately, but talking to NGOs there, and I think the government there is, in fact, they think they would like OEP to have jurisdiction there because they're simply not large enough to have another independent body. But frankly, I think I have to be so careful, but it's a bit presumptuous of the OEP in interim form to start being too active in Northern Ireland until the Assembly agrees, because that's their right, and it's a political decision. But there are, and it's again, it's always quite difficult. There are some reserved matters, what we call reserved matters, which touch the environment, which are part of the UK, and we have jurisdiction there. So again, there'll be one or two points to make.
And it's interesting.
Does that make sense?
It does totally make sense. I think it's interesting. The point about reserved matters, I wonder how important that's going to become, because in the provisions about environmental principles in the bill, it's made very clear that it applies to UK reserved matters, and that the Scottish regime around environmental principles will not apply. So trying to carve out as much kind of regulatory space as possible for the bill. And the work.
And it's not easy. You can look at House of Commons papers. There's so many complicated things which are reserved or not reserved. I've got a question here, again, on the Zoom, and any of you can do it. We talk particularly a lot, particularly OEP functions, about public authorities. Would you like to give any guidance on what public authorities means? I mean, either is it defined in the bill, or where would one look to use that? Perfect.
Can I just, just while Tim's looking for that, I mean, one also has to think that there's public authorities for the OEP's purposes.
Yeah,
and I'm guessing that's the question. But have a look, going back to the policy statements on environmental principles, they only apply to ministers. They don't apply to local authorities. They don't apply to courts. So there is an argument that environmental principles could have a different life independent from that. A different version of that.
It is defined. It's defined in clause 30, clause 33, and it's broadly similar to the way it's defined in the Human Rights Act. So, person carrying out a function of public nature, and there's a lot of case law on that because you've got the same phrase in the Human Rights Act. But it's not a devolved function, and then there are various exclusions, including notably Parliament, Scottish ministers, and the OEP itself. That's the black letter law.
Okay. And I presume that there's also a lot of case law on environmental information regulations. Again, probably draw from it. So I think, I think this is public documents. I mean, I think, for instance, water authorities would be under the direct review of the OEP in that sense, in relation to their public powers. But we had a recent case, environmental information, where the upper tribunal said that Heathrow Airport PLC was not a public authority for those purposes. So it's certainly broader than the Environment Agency, Natural England, and local government. I think that's pretty clear. Right. Any other? Sorry, you always say there's other buttons to check. Whoops, you send it off again. God blimey, I never thought I'd be used to this. Could not hear the question. Well, that's useful. Sorry, please repeat the questions. That's my problem. Please ask Tim to use the microphone. Sorry, this is not. And we've had that. Well, I've got. We're all the time. I've got one question to all three of you, because we've heard. I'm now a non-executive director of this OEP. What I should say, we've heard a lot of challenges and degree of pessimism, maybe a degree of cynicism. I would say that on the interim OEP, a lot of these issues we're wrestling with and we're aware of. What I should say on the OEP is going to be pretty lean. I was going to say lean and mean. It's got about just over 50 staff. that sort of size might go up. But what is, to me, is positive, it's attracting a really good range of applications of staff. The people who've already joined it, they are very bright, they're very enthusiastic. And, you know, I think that, but I think, you know, we're all aware we've got to use our resources very carefully, very wisely. We've got to be very strategically and work out where we actually can make a difference in our range of powers. And that's going to be quite difficult judgments, you know, and we cannot, and I think everybody understands that, we've got to use a strategy. You know, we're not going to be able to take up every single complaint, nor does the European Commission. It used to try to, but it doesn't. It has a kind of rather vague strategy of how it singles out complaints. I think the OEP will be a bit more, has to be more explicit about that. And that's the advantage of that. So, you know, it's not going to, and as you said, there are going to be certain environmental issues where it's not going to be necessarily the right for a complainant because of the things you said. To me, the really interesting question, and I don't know the answer yet, is that, you know, we have people sitting here in local authorities. I just know from my own instinct that if you get a challenge from a rather aggressive NGO or an individual saying, you've acted illegal, your natural reaction is to be quite defensive because, you know, you don't want to lose face. And you know that if you lose case or, you know, they're going to crow because that's what you do as an NGO. You've got to. If you get something from the OEP saying, look, we consider you've got a real problem here, that you actually, I take all the one this year, but we think you need to change. You know, will their reaction be different? Because the OEP is quite considered, careful public body. Will they treat it in a rather different way? And that I have no idea. I mean, I hope they will, because we know, and we've been talking again, I don't think I'm being discreet, you know, other bodies, Quality and Human Rights Commission, other bodies who want to handle these things. And it is quite interesting. You can get very different reactions. So maybe you know, the OEP is not going to replace all judicial reviews. It's not going to replace a lot of litigation. It's going to be a complement to that. And I think that's what's going to be, to me, really interesting in the future. But sorry, my question to you all three is, what would be your one bit of advice to the interim OEP as it's going, you know, beginning to go there? Oh God, you know, real practical advice. We're dealing, you know, dealing with legislation we've got. That's roughly, you know, there might be changes, but not massive. We know what we've got, our functions. We've got our budget guaranteed for 2-3 years for the moment. We know our size. What would you say if you were now, I asked you, give me one bit of advice?
Tall order.
I know. Well, why not? Sophisticated panelists.
So
One.
No. So I'm thinking in terms of enforcement, really understanding the particular, there are many weak spots in Chapter 1, Part 1, but really understanding them and focusing enforcement around that.
Yeah, I have noticed stuff.
I do want to say more than that, Richard.
You can do sub-clauses. I've had that before. There's still one sentence.
Two quite different points. I think probably figuring out the scope of what is the failure to comply with environmental law.
I'm not sure I'm well placed to offer a review, but what I will say is I've been involved with parliamentarians in some of the amendments I've talked about. It's the detail of which I talk about. Certainly one of the things the government is saying very much, you just reflect the government side. This won't be all about investigation at the end of the full process of investigation, but kind of having a relatively informed exchange during the investigation phase and getting public bodies on side. So that, no, I don't care. Well, that's whether it will work like that. Public bodies themselves have limited resources. Their own facts. I don't know.
Okay, well, we're right on time. No, 12 o'clock. Friends, the trouble I'm like Boris, well, I'm not like Boris Johnson, but I'm like Boris Johnson. I run my watch fast and then I can't remember whether I put it onto real time. But can I thank all the panelists very much, very interesting. I hope people have learnt more. I've learnt things on this sort of great voyage that we're entering on. And can I thank the people on remote who've asked questions. Right, welcome to the second session from this morning. And the next session will focus on recent developments in relation to the Aarhus Convention. And James Maurici will be speaking. James is known to many, one of the leading practitioners in the country in relation to environmental and planning law. And James has had the privilege, if that's the way to describe it, of defending the airport's national policy statement in Plan B at first instance, and the Court of Appeal, and other cases such as CPRE Kent in the Supreme Court recently, and is also experienced with the Aarhus Compliance Committee and is acting on the Brexit communication to the Compliance Committee at the moment. Thank you, Joe.
Thank you. It's going to work the slides. Can't see it at the moment, but I'll check. Well, not much happening on the slides. Well, here we are. It's working. Good. So what I want to cover, if I can, is really four things. First of all, domestic cost cases concerning the Aarhus Convention. Secondly, any references to Aarhus in domestic cases going beyond costs, and these are recent cases over the last 12 months or so. Then look at three sets of recent findings by the Aarhus Compliance Committee that are going to come around quite soon, I think, in argument in our domestic cases. And then look at some other cases that are in the pipeline before the Compliance Committee, and which, again, I think the arguments in those are going to appear in our domestic cases before too long. So just a word on status. I mean, as you all know, I mean, save to the extent that the Aarhus Convention is incorporated into our law via principally CPR in relation to costs and interim relief, and then any retained EU law, the Aarhus Convention has the status of an unincorporated treaty and is therefore not binding in our law. And similarly, the Compliance Committee's findings are not binding, and I'm going to touch on that a little bit more later on. Now, it has been said by Lord Carnwath in the Walton case that the Compliance Committee's findings deserve respect, and I simply ask, do they? And I have serious doubts about whether they do deserve respect. They're not a court. They always tell you they're not a court. They certainly don't decide things like a court or behave like a court. My favourite example that I always give is when I was making submissions to the Compliance Committee and one of their telephones rang, mobile phones, and they took the call. Now, that's not really the behaviour of the court. There are other stories that are even more horrific about appearance of bias in that first Port of Tyne case, where one of the Compliance Committee members was married to the NGO representative and it was undisclosed. And these kind of things really do bring into question. What brings it more into question, and I'll come to this, is some of the findings that they're making at the moment, which I think are, if I'm going to be nice to say that they're surprising, I could use other words, I probably will later on. But the other thing is, of course, the Compliance Committee's findings themselves don't bind even in international law, never mind domestic law, until they are endorsed by the meeting of parties. And I want to talk about that a little bit too, because there obviously was, over the last few years, findings of non-compliance against the EU, and the European Commission has provided a very interesting model of how you can block the meeting of the parties from endorsing the findings of the Compliance Committee when you don't like them. Now, if the EU Commission thinks it can behave in that way, so can other member states, and I think they've taught a very bad lesson, depending on your perspective, about how to avoid findings. So before we get to that exciting stuff, I just want to talk a little bit about domestic cases on costs. So there have been a handful of things in the last year. First of all, Friends of the Earth, Secretary of State for Transport, one of the many kind of footnotes to the AMPS Plan B litigation in relation to costs. A very short but pretty important point that the capped costs, which the Court of Appeal held, the capped costs recoverable from a claimant or a defendant specified in the Aarhus costs rules are absolute and unqualified figures and they are therefore to be treated as inclusive of that, which, I mean, for small NGOs, organisations, does actually make a bit of a difference, but that is very clearly now the position and reaffirmed in a discussion that followed in the Cara case as well. So that's the first one. The second one, just to mention CPRE Kent, which I was involved in the Supreme Court. That was a case principally about whether the Mount Cook rule, that you are entitled to multiple costs generally against a claimant at the permission stage when you're refused permission, whether that rule stays, whether that is the correct rule, whether it was inconsistent with Bolton. But in the course of that discussion, you'll see Aarhus does loom quite large by the Supreme Court looking at what the practical consequences would be of this, given that most claimants are going to have protection of 5,000 and 10,000 anyway, whatever stage the proceedings have reached. And that did exercise some influence over the result in that case. I thought I'd just mention this one, Danning. And the reason I mention it is that so many times I'm asked when I'm defending a judicial review for a defendant or interested party, can we challenge the Aarhus cost protection applying? To which my answer is almost always no, not really, because of Venn, where the Court of Appeal essentially said that environment and environmental law to which the Aarhus costs rules apply is really widely defined, such that it would catch most, if not all, planning matters. So, you know, arguing that you're substantively outside the convention in a planning case or environmental case, really very difficult to do. That's certainly always my view. But I couldn't help just mentioning this. Recorded in the main judgment by Mr. Justice Stein, that His Honour Judge Jarman QC had rejected the claimant's contention that the claim was an Aarhus Convention claim, and they hadn't sought to renew that aspect. It was a kind of classic planning JR in relation to a decision to allow a pub to be residential. Given the wide definition of environmental cases, land use, etc., I just can't see why it isn't an environmental claim as defined. There's no explanation of what happened there or what the reasoning was. But for me, I just don't see there is a lot of room to argue that planning environmental cases are not caught by the substantive rules of the convention anymore. But clearly, maybe I'm wrong. There may be some room here, because it seems there are decisions out there saying that some types of judicial review in the planning environmental might not be called. So watch that one for the future. And then Wingfield and Canterbury, I mentioned this one briefly. I mean, this was an application, there's been a few of these recently under CPR 52.31. So you get refused permission to go to the Court of Appeal. We all know, or we should know, that's pretty much the end of the road. It should be the end of the road. But there is an exceptional jurisdiction to seek to reopen that finding that permission should be given. The Court of Appeal, not surprisingly, doesn't very commonly exercise that power. And one can see how welcoming they are on the whole to those applications by reference to the opening words of the judgment, where the court says, the question raised by these renewed applications, put at its simplest, is when must an unsuccessful litigant accept no for an answer? Ouch. I mean, that is, I think, quite clear where the court's heading from that point. But interestingly, I mean, obviously the claimants there had Aarhus cost protection in the original litigation. And the Court of Appeal said that these kind of what they regard as unmeritorious applications are damaging for all kinds of reasons, including that they are imposing unnecessary burdens on resources, taking away from other claims which may have more merit and also have Aarhus protection. So, I mean, you know, all I can say is be very, very careful before you seek to exercise that jurisdiction, or you will face serious trouble. That's not to say it doesn't sometimes succeed. And there was an incident recently in relation to group litigation on environmental torts abroad, where permission was refused, and the Court of Appeal did reopen it, but it is very, very, very rare indeed. And it does raise a more general issue, which I'd love to have more time to discuss, as I don't. But given that you have this Aarhus protection for claimants at 5 or 10,000, how do you control bad behaviour in the course of the proceedings? What if claimants behave unreasonably? Cost is normally the way in which you control that kind of behaviour. Is there a way around it? Now, there was some discussion of that, I think, at one of the CMCs in the Heathrow litigation, where Mr. Justice Holgate posed that question. Is there a way around this? You know, if people do behave badly, can it be controlled? And the only thing I can think of is wasted cost orders against the lawyers. because I don't think that would be caught myself by the Aarhus cost rules, or I'm not sure the Aarhus Compliance Committee would agree with me, but I think if we actually look at convention, that may be the correct position. So, can you go after the lawyers? That would be the only thing I can think of. Any punishment against the claimant would clearly be banned, I think. And just briefly, another footnote on the Heathrow litigation. I won't spend time on this. Another interesting footnote, Aurora, who, as you may know, were at one point promoting their own alternative Heathrow expansion scheme, effectively asked Heathrow to disclose all of their information about their own proposals, effectively, saying that Heathrow Airport was public authority for the purposes of the environmental information regulations. And somewhat bizarrely, in my view, the Information Commissioner agreed that they were a public authority. Heathrow Airport, not liking that decision, strangely enough, appealed and were successful before the First Tribunal. It's a very detailed, lengthy, and actually excellent decision, trying to navigate through the European Court decision in Fish Legal, which is quite messy about when things are public authorities or not. But it's actually an excellent decision, and there is quite a lot about Aarhus in there, including references to the Aarhus Implementation Guide, which provides some guidance around this issue of what's a public authority. I need to move on to the fun bit, really, which is these three cases in the last year. The first one is case 90. So this is a Northern Ireland case. A company expanded its concrete production plant without planning permission and in close proximity to a SAC, so European Protected Habitat Site. The development included, perhaps unfortunately, a settlement lagoon for contaminated materials in the floodplain. Not sounded a good idea, but that's what they've done. Some enforcement action was very slowly kind of taken in Northern Ireland, and the company in response applied for retrospective planning permission, which eventually, and I do mean eventually, they got. The communicant, JR, that lost and was awarded, had costs awarded against them, albeit capped at 5,000 in accordance with the Northern Ireland version of the cost rules. Unhappy, the communicant, the claimant, became the communicant, took the case to the Compliance Committee in Geneva. And there were some pretty interesting findings. So the first two, I think we take together, covered by Article 6 of the Convention, which essentially is all EIA development, cannot be permitted after it's been commenced, save in exceptional circumstances and subject to strict and defined criteria. Now, on the face of it, that seems to go potentially even further than the restrictive approach that the European Court's taken to retrospective EIA development. See Commissioner Ireland and see our own domestic interpretation of that in cases like Ardagh and Chester City Council. How much further, you're going to struggle to understand because of the kind of quite sparse reasoning really about what this means. And then secondly, and this is where I think things get even more surprising, such development cannot become immune from enforcement or be the subject of a lawful development certificate. Now that is contrary to the European Court's position on this, and certainly contrary to our own domestic law in the Evans and Fraser case. I mean, if you just think about the logic of where this is going, I mean, effectively the Compliance Committee is suggesting, or it would seem they are suggesting, that one ends up with a position where you have to rip down your unauthorised development, then apply for it, then rebuild it. I mean, that can't possibly be a sensible solution. So that's one set of issues which we'll have to deal with because our domestic authority does not support that position. I don't know how we're going to deal with that. And then it gets worse or better, depending on your perspective, I suppose. There's a breach of the standard of review because the High Court did not itself consider whether this was EIA development. And really, there's a series of paragraphs 118 to 120, which are quite amazing, really. But what they confirm is that a reviewing body, which includes a court, must review all the relevant facts, evidence, and arguments before it, and based on that review, determine for itself whether the contested decision is lawful. This requires the court to carry out its own assessment in the light of the evidence as to whether the applicable requirements were met. So, for example, they say, in a challenge to an EIA screening decision, the court must make its own assessment based on all the evidence put before it as to whether the proposed activity was likely to have a significant effect on the environment and require an EIA. Albeit, apparently, this doesn't mean they've got to do an entirely fresh analysis. Now, that is a finding that, again, I would say very surprising, contrary to our own domestic case law, cases like Loader cases going back to a case called Mulster that David and I did at turn of the last century. It's extraordinary. You're saying that a court has to reach a planning judgment on whether environmental effects are significant. I mean, that just doesn't work in our system. It just doesn't work at all. I don't know quite how we'll deal with that one. And then linked to it, it's a breach of the Aarhus Convention that developers have a right of appeal, but third parties don't. So that old chestnut, third party rights of appeal in planning, and they didn't make a recommendation on that one because they said, well, actually, if you follow our recommendations by introducing full merits review in the judicial review procedure, then you don't need to have an appeal for third parties because they can raise all the same points in judicial review. Which I don't know. The only word I can think about for this is bonkers, to be honest. But we'll see where it goes. I mean, again, it's so contrary to everything that's established, and it's also contrary to EU law. Because if you look at LODA, the EU itself, the European Court does not apply this, does not require you to actually, as a court, go and review the decision yourself and decide whether it has an environmental effect. And then finally, this is the only bit the government actually won on, was that the claimant didn't complain about the 5,000 they had to pay to the other side, but they complained their own costs for 160,000, which, there we are. But that wasn't a breach, because although they were shocked at how high these costs were, their own costs, there was no evidence about how they could have mitigated it. So could they have entered a conditional fee agreement? Could they have used one council, not two? That sounds like a terrible idea, but that's apparently what they suggested. So that's the only bit that the government, I think, had a real success on. Extraordinary, really, set of findings, but not the end of the extraordinary findings, because we then move on to case 131. So this is a planning permission for redevelopment of a former hospital site in Merton. There was a negative screening opinion which the council unfortunately failed to upload onto the planning register. There were ombudsman complaints that had some success. There then were discharges of conditions under the permission. These were said to require screening. The council disagreed. The claim was judicially reviewed. Claim was marked totally without merit, and costs were awarded against them, capped at 5,000. Unhappy, the claimant became the communicant and went off to the compliance committee. So the findings of breach on this occasion. Not making the documents available promptly online, well, fair enough. I mean, the council should have done that, and they didn't, so fair enough. This is the one, though, that I think is, again, very surprising. And again, I probably use the word bonkers, frankly, but the legal system, which sets the time for bringing judicial review, must set that from the date the claimant knew or ought to have known of it, not from the date of the decision. Now, that, again, completely contrary to the position in our own domestic law going back, well, as far as judicial review goes back. And then a couple of other things. Well, this one's quite interesting, that the costs that the claimant was awarded at £250 an hour were a breach of the convention, because that was more than the solicitor for the local authority was actually charging their clients. Now, this is really common for local authorities and GLD. They do charge back more to the opposing party than they're actually paying between themselves. And there's a very old case from the 70s that supports that being allowed for government bodies. No one's really challenged it for a very long time, but the Aarhus Compliance Committee have challenged it. They didn't like the 5,000 at the permission stage, too high. That's similar to other findings they've made. And then they also said they didn't like the fact that litigant in person recovery rates were too low and lower than lawyers, and they needed to be higher. Well, that would involve changing the whole of the CPR on LIP costs. So some interesting findings. And then the third one, briefly, these are extraordinarily exciting proceedings to go off to Geneva, litter abatement proceedings against a council brought by the local MP because the council wasn't collecting green waste. Following proceedings in the magistrates court, the claimant lost, had costs awarded against them, then tried to go to the High Court, case stated, lost again, didn't like it, went off to the compliance committee. The proceedings were held to be prohibitively expensive, but perhaps the strangest finding in this one is that, taking account of the fact that the council made an offer on the door of the court, if you withdraw this because it's rubbish, we won't seek any costs against you. No, rejected, goes to court. Apparently you can't take that into account because it's unfair and inequitable. I mean, that's just ridiculous, absolutely ridiculous decision by the compliance committee. So there's a situation we're in, increasingly radical findings, I would say, in many regards. They're completely contrary to our domestic law. Many of them are contrary to EU law. Some of them, as I've said, I would regard as simply bonkers. They fail to understand our legal system in a number of respects, and that is a real issue when you go there. There is just complete lack of understanding, not surprisingly, of our legal system, particularly because we are one of the common law jurisdictions, very little experience by the members of common law. Huge departures from our established law in some of these decisions. They're very difficult to justify in my view, and also they seem to ignore European court jurisprudence. And that is something I have noted. The Aarhus Compliance Committee doesn't seem to pay that much heed to the European court. You get our European court case and they're like, well, we're not bound by that. Well, you're not bound by it, but I would suggest you have a good look at it before you leap off and do something different. So what will the government do? Will it accept these findings? We've got a meeting of the parties coming up quite soon. Will it try and fight them? Will it take the Commission's model of what's probably bad behaviour, of fighting tooth and nail to resist these findings being adopted? Will our courts reject these findings as being not binding? I mean, I hope so, because a lot of these things are not right. Where does all this lead? And now I know there's been a conference, I think this week or maybe last week, about whether the UK is a rogue state under the Aarhus Convention. Well, I don't think so myself. I think the committee could be said to have gone rogue. But I mean, the idea that our environmental law is worse than some of the other countries which are members of this convention is not right. I mean, I think one of the issues here is, I remember the former chair of the Aarhus Compliance Committee saying that NGOs in this country had to be restrained in the claims that they brought, because otherwise the whole thing's going to get bogged down and not really work. And I think our NGOs have been quite restrained in this country in terms of going to the Compliance Committee, but I think also these individual complaints, which the committee then goes a bit bizarre on, are beginning to bog the system down. And where does that take us? I mean, it does seem to me that I was taught international law by the late, great Professor Ian Brownlee, and he said that the most important thing about an international court tribunal is it has to understand the limits of its own powers, the limits of what's acceptable for it to do and still be followed, because no one actually has to follow an international tribunal or court in their domestic systems. And I think this is what the Aarhus Compliance Committee has forgot, or maybe never known, that there is an issue about going too far and about what the reaction to that will be. And there's another issue. So the Brexit communication was lodged in October 17. We still haven't got a hearing date for that, which makes a bit of a mockery of the Article 9 requirement for timely decisions. That doesn't apply to the committee itself. But the problem is, because they're taking a lot of these cases, some of them, not really meritorious, but taken all the way through, they are unable to cope with the volume of cases. And that means the whole system will grind to a halt. And we had a similar issue with the European Court of Human Rights for a long time, and maybe still will do, about these cases taking too long to be determined. And then the other cases coming up, and I mean, there's no prizes for guessing what the result will be, but there's a hearing about whether Wednesbury is consistent with Article 9. I mean, obviously the answer to the Compliance Committee is no, given that they want full merits review. We've seen that. But this issue was first raised in Portatyne back 10, 15 years ago, that Wednesbury's not good enough. That view was expressly rejected by the Court of Appeal in Evans. It's a brilliant judgment, and if you want to know why the Compliance Committee is wrong, then you need to read that judgment. And despite a very strong defence by the UK government, I'm not involved in this one at all, it seems inevitable that they will rule that Wednesbury is a breach. I mean, particularly given what we saw in C90 in the context of third-party appeals. So I think we know precisely where all of that's going. Anyway, that's my talk. Or was it a rant? I can't remember. Talk over. Thank you.
Thank you, James. James, can I kick off by asking you this? And I think I know what your answer is going to be, or your rant. Between the UK legal systems and the EU legal systems, if we just bear in mind, although we're not part of it, that there are similarities, there are certain legal norms which are applicable across the systems, such as the principle of certainty, non-retroactivity, and legitimate expectations, for example. To what extent, if at all, does the Compliance Committee pay attention to generally accepted international legal norms?
Yeah, I mean, that is an interesting one, because I think particularly in EU law, you've got general principles of law, which obviously incorporate all of those things. And actually English law in the time that we were in the EU had quite a big influence on the development of those general principles. I mean, a number of them, when you look back, did actually start from English Advocate Generals or English cases being cited. So we know the EU does that. Within the Compliance Committee, I mean, I think they'd say they did pay regard to these kind of international standards, but I think in reality they don't. And I think part of it is that over time, I think the European Court came to understand a little bit more about common law systems and what the root of our principles are. I think in the Compliance Committee there is just no understanding of that at all, and no recognition of the principles that underlie some of the kind of key concepts in our common law. And I think it's a real issue. I mean, legal certainty doesn't seem to be of any interest at all to the Irish Compliance Committee, as far as I can see.
What is the percentage membership of the ACC in terms of those with legal experience?
Well, I think most of them, they don't have to have any in theory, but most of them do have legal experience, but they're not, it's often not, doesn't have to be practitioners. So there are a number of academics on there as well, but most of them do have legal experience.
Sorry, that wasn't.
I wasn't targeting. I know you weren't targeting that. I mean, the reality is that they don't have to. I think the problem's been that there have been over time some very good people on that committee, but there is quite a big turnover of people on there, and I think the problem is at the moment there isn't really the right understanding of the common law basics, or indeed the basics of international law, in my view. It's a very, very radical tribunal. And I mean, it does have this approach. I mean, if you're acting for a claimant or communicant, it's great. I mean, they literally don't want to believe anything that the government says to them. I mean, they literally just don't want to believe what the government says. It is quite extraordinary. I mean, some might say it's a very good system to have, but they literally, it's almost impossible. If you say, well, this is the position, it's like, no, don't accept that that's correct. Well, okay. You put evidence in, they still don't accept it. And it's very, very difficult. It's almost institutionalized. Do not trust anything our government, not just our government, but our government says to you. Maybe that's a good thing. I think it goes a bit too far. I think there are limits to this. I mean, I think, sometimes they do need to just step back and listen and think maybe that is the position. So it is an extraordinary tribunal. It's an extraordinary place. I mean, in terms of advocacy, it's an amazing place to appear, because it is a challenge beyond all challenge, really. And I mean, I do remember the first one I did, Edinburgh Trams, it was the first one I did. And we had a whole day, it was all about public participation, effectively. And we had a whole day going through all the procedures for Transport Works Act, all kinds of other things, how do people participate? And the very last day, right at the end, one of the tribunal members who hadn't said anything asked a question, and the question was, are there any procedures for public participation? So I was thinking, well, that's all we've talked about for 2 days. So I thought, yes, oh, thanks very much. And that was it. And you just think, well, where do you really go from there? I mean, it's kind of, just bizarre. But you're trying to get across your system to potentially 8-10 lawyers who have no grounding in common law or your system. It's difficult. I mean, if they were trying to explain their legal system to me, I'm sure I would be completely at sea as to what was going on. And that's the position. So I'm ranting again, aren't I?
This is sounding like therapy, Joe.
Yes. Is that not what this is?
So have you got a microphone? So we've got several questions. Oh.
Sorry, can I just relate your talk back to the discussion of the Environment Bill?
Right.
Because it strikes me that what you're highlighting with the Compliance Committee is the importance of institutional design and the importance of courts.
Yes.
I mean, I don't want to get into the details, and I think on some points, but you're highlighting how much we have developed these structures for dealing with conflict.
Yes. Yes, I think you're absolutely right. And I think the thing is, I think when the Irish Compliance Committee says we're not a court, that they seem to think this is a good thing. But I'm actually not sure, given what the things that they're deciding, that it is a good thing that they're not a court. It doesn't matter who is on the committee. It does matter, though, what their role is, what their function is. And to go around saying we're not a court, but we're deciding legal issues, I just find that quite disturbing. So, yeah.
Yes.
Thanks both for an interesting talk on this. Just 2 points of clarification. The first is that in case C90, the point about third-party right of appeal, I think that's in the draft findings of the ACC, and the final part is not. I think being pushed back to C156 to be considered.
Yes, they say we don't like it, but we don't want to deal with this because it can be dealt with in the context of the Wensbury case. Well, I mean, the thing is that in itself, I think, shows a kind of fundamental confusion of thinking, doesn't it? Because one is about review, judicial review, and the other is about merits appeals planning, and they should not be the same thing. I mean, they're not the same thing here, but I think the committee doesn't see it that way. And you're right; they pushed off. They made no recommendation, albeit they did, I think, record their findings. That they didn't make any recommendation.
Which I think, so C156 hasn't been determined yet, and it's interesting to note that in the next panel of people being elected to the ACC, I think Eleanor Sharpston has been nominated by Luxembourg.
Interestingly, Eleanor was the advocate on the other side against Mia James in the Bolster case many years ago.
Yeah, so I think we know which way her decision is going to go on that. She can basically reverse that decision from 20 years ago. Yeah, I mean, I think that's. I did see that, and I thought that's probably going to only help the decisions go further in that direction, as far as I can see. Although on the other hand, Eleanor is actually an excellent lawyer, and at least we'll get some. I may not like her findings, but at least we'll get some proper reasoning for what the decisions are, which I think is what's often missing. It's quite kind of like leap into this and just here's our finding. And I think if whatever happens, we won't get that from Eleanor. I might not like the end result, and I'm sure I won't, but I think we'll get some reasoning, which is what we need.
Actually, a good example of her reasoning was her response to the shoddy treatment she received from the EU when she was unceremoniously discharged as Advocate General. She wrote a very good paper, which a very sobering reading.
Yeah. Yes.
James and I first met across the floor in Geneva in 2012. One thing that has worried me since has been the revision over the costs, because that you've taken the £5,000 as given, but I rather understood that people can trawl through your assets before you're, before you're say that you can be limited to £5,000. Now, some of this in the room of, say, inherited your parents' house or something like this, and you've let it out, and you've got various bits and bobs of income, which on paper at least makes you look quite a rich person. This is putting off people because they just don't want some judicial decision on whether or not they're qualified. They can be limited from £5,000.
Yeah, I mean, I think obviously those rules, those cost caps are sort of starting point. You can you have to put in stuff about your means. A lot of people find that difficult. I mean, there are procedures to keep that material confidential to the other parties of the court, but you're still disclosing your financial assets in a way that a lot of people are not comfortable with. I understand. I mean, my experience is, of course, people do have to put this material forward to get Aarhus cost protection, but I haven't come across a huge number of cases where there's actually been challenges to the level. There have been a few, but there are not a huge number of those. I mean, having said that, I think I'm involved in one with an NGO where we are challenging because they are quite a wealthy NGO. We don't think 10,000 is sufficient, but mostly those caps are applied. And also my experience is that the court's not too keen to depart from them, actually. But, you're right, you've still got to put that material forward. And some people, I think it's fair to say, are uncomfortable about putting that material forward, even with confidentiality.
But just picking up a question on the Q&A in this context, how does that square with someone who has gone into proceedings, incurred costs which presumably have been the result of their own instructions and their own wishes, and then get a ruling, as you got in C90, which says their own costs are unreasonable?
Well, their own costs are high. Well, the court, I mean, the compliance committee kind of didn't quite go that far, but yes, what they said was they're very high. We're a bit shocked, how high your own costs are. But I think the reality is it is very difficult to see how this can properly be regulated by the Aarhus Convention. The cost that people incur bringing their own proceedings. It's very hard to see how a tribunal can go around regulating that beyond what we already have, which is, of course, cost and tax. If you're in dispute with your lawyers about what the level of costs should be. I mean, it is. I've always found this own costs thing, which is part of ours, a little bit extraordinary. On the other hand, I think some of the compliance committee find our legal system extraordinary. I remember the chair once asking me, "Are you telling me that barristers can charge whatever they like?" I said, "Well, not quite, but I mean, but there's a market, and there's a legal services market, and if you're going to undermine that, okay, some people might say that would be a good thing to do, but it's a pretty fundamental thing to take on, isn't it?"
Yeah, well, I mean, there's a general lack of understanding in civil jurisdictions about our cost regime, because I seem to remember a function that we attended. Maybe it was me. I know Richard Macrory was there doing magic tricks. Yes. But I sat next to Ludwig Kramer, who, of course, was at one stage the commissioner, the environmental directorate, and he had nothing really flattering to say about our cost regime.
No, I mean, the thing is, I think, with our regime, the difference with the civil jurisdiction is not understood is that in the civil jurisdiction, the vast majority of the work in cases is done by the judge. They are the investigating judge. And so the state is effectively funding the vast majority of the work that's done in litigation. In our system, we all know it doesn't work like that. The lawyers do the vast majority of the work to bring the case to trial. Of course, that means lawyers are going to be charging more. And in a market where, costs will be incurred. And I think there are other, not so much in judicial review, although it can be, but in other proceedings in environmental law, our provisions for disclosure and in judicial review duty of candour do rack up the cost of proceedings massively. And a lot of the civil jurisdictions do not have a disclosure system. And that's one of the reasons, of course, why we're such a popular place to litigate foreign disputes, is because disclosure gives you the best chance of getting the other side's documents.
And you would slightly expect a tribunal that was looking for participation to applaud a situation, principles which we have here in judicial review, where the court insists on candour from the parties.
Well, I mean, I remember I hosted in Chambers quite a senior Italian lawyer, and I was trying to explain to him disclosure. And he said, so you have to give documents that are unhelpful to your case to the other side, or it's a breach of your professional code. Yes. In Italy, it's the reverse. If you give documents to the other side that harm your case, that's a breach of your professional code. And I was like, well, there we are. It's very hard to kind of, it is so different that you need to try and understand the differences between the systems to make something like Aarhus work. And the problem is, I just don't think that's what we're seeing from the compliance committee. We're not seeing that understanding of our system.
Thank you, James. There are a couple more questions on the Q&As, but I think we're really out of time. And I'd like us to keep us on timetable for the rest of the conference. So can I just ask you to thank James for his fascinating rant? And you can charge him for the therapy session later. Thank you very much. Could you be back here in time for this afternoon's first session, which I believe is at 1:40. Is at 1:40.
Thanks for coming back after lunch to this environmental law conference from Landmark Chambers. We hope this afternoon's presentations and discussions are going to be useful and informative. I'm Dave Forsdick QC, and I'm going to be chairing the next session. I'm joined by Jenny and Matthew, who I'll introduce properly in a few moments. We're going to be covering two highly topical issues: climate change, current issues and developments, and also air quality and how the bill deals with air quality. I've been asked to just go through a few housekeeping points before I do the formal introductions for people who weren't here this morning. First of all, your microphones are automatically muted, so you don't need to adjust any of those. We very much welcome questions. I've got a little iPad on my desk there where any questions will come through, and we'll do our best to answer them at the end of the session. Can you please submit them via text in the Q&A section of at the bottom of your screen? And if you would like to remain anonymous, then just tick the box "Send anonymously." This webinar is being recorded, and you will receive a link to the presentation and the recordings and the slideshows and so on immediately after the event concludes. If your connection drops off at any time, please just dial out and dial back in again, and that normally works. And thank you for the comments this morning about problems with the audio. We'll do our best to use microphones when we're doing the question and answer session. The next hour or so, we're going to be addressing two highly topical matters: climate change, which you'll have seen a flurry of case law in recent past, which is going to be addressed by Matthew, and then air quality in the bill, which you'll be reading about most days in your papers. These are the very issues where environmental law is likely to develop in the future, and where there are many issues popping up on a day-to-day basis. And we've got two expert speakers to guide us through the maze of complexity on both issues. Matthew Fraser specialises in planning and environmental law. His recent environmental cases include Banks, which was the challenge to the refusal of permission for an open cast coal mine, I should say, acting for Friends of the Earth. And next week, I think it is, he's in the Court of Appeal on the Finch case, which is obviously the oil well, where he's acting for the developer. Jenny has appeared in many environmental related challenges to planning decisions in the High Court and Court of Appeal, including a number of cases relating to the habitats regulations, and obviously also her particular expertise relevant for today is in respect of air quality, where she acted in the case concerning the proposed international cruise liner terminal in Greenwich. She took Silk this year and has been selected by a panel of judges as one of the planners Women of Influence of 2021. So with no more ado, I'll hand over to Matthew.
Good afternoon, everyone, and thank you very much for that introduction, Dave. As Dave said, I'm going to be speaking about climate change, some of the current issues involved in this area. I think it's fair to say that Jenny and I have been given the two most unimportant aspects of environmental law. So this is how I'm going to proceed, if I can flip through to the next slide. And away. I'm clicking on the mouse. I'm just going to see if it lets me. There we are. Good. So in terms of a structure for the talk, I'm going to start by setting out the legislative framework, which we will be very familiar with, looking at some of the recent policy changes that have been going on, then some current planning decisions which are pending an outcome, looking then at some recent cases in courts, and then a few pending or future cases to keep your eyes on. Starting with the Climate Change Act 2008, this is of course the centrepiece of the UK's response to climate change. It sets a target for the year 2050 for the introduction of targeted greenhouse gas emissions and provides for a system of carbon budgeting. It establishes a framework for the UK to achieve its long-term goals of reducing greenhouse gas emissions through setting emissions reduction targets, both in statute and in carbon budgeting. The Act also established the Committee on Climate Change, the independent body of experts who advise the government in relation to emissions reductions. And when the Act was first gained royal assent 13 years ago, it placed the Secretary of State under duty to ensure that the net UK carbon account for the year 2050 was at least 80% below the level of net UK emissions of targeted greenhouse gases in 1990. And it was this target which was amended in 2019 to at least 100% below the 1990 level. And that is what is known as the net zero target, which you see coming up time and time again in the climate change litigation. And that is designed to ensure that national legislation is consistent with the goals of the Paris Agreement. The Paris Agreement, of course, ratified in 2016. The UK is one of a number of signatories, and it aims to strengthen the global response to the threat of climate change, including by long-term temperature goals of holding the increase in the global average temperature to well below 2 degrees Celsius above pre-industrial levels, and also pursuing efforts to limit the temperature increase to 1.5 degrees above pre-industrial levels, and that's Article 2.1 of the agreement. There are also the well-known duties in the Act to, firstly, Section 4 to set carbon budgets for successive 5-year periods to 2050, interim targets along the road to the final net zero outcome in 2050, and then in Section 13, the obligation on the government to prepare policies and proposals to enable carbon budgets to be met with a view to meeting net zero. The latest carbon budget, the 6th carbon budget, is found in the Carbon Budget Order of 2021, which was laid before Parliament a few months ago. It accepts the recommendation that was made by the CCC for a 78% reduction by 2035, which would put the UK ahead of other similar large European countries and in line with the Paris Agreement. The most recent carbon budget has been described by the CCC as world leading. Policy, we've seen in the Prime Minister's 10-point plan that was published late last year that a comprehensive net zero strategy will be published in the run-up to COP26 next month. And that will be a centrally important policy document for achieving net zero. We don't yet know precisely what it's going to say, but we do know that it's going to need to be impressive and consistent with the fact that the UK has the presidency of COP26 this year, and that will supersede the current clean growth strategy. We also have last December, in accordance with the Paris Agreement, the UK communicated to the UNFCCC, that's the UN Framework Convention on Climate Change, that a new nationally determined contribution was being published by the government, and that commits to a greenhouse gas emissions reduction of at least 68% by 2030 on the 1990 levels. Again, this is a material change from the previous NDC, which sought at least 40%, that was in line with the EU's promise. And again, like the carbon budget, this puts the UK presently, certainly in terms of what it's committing to, ahead of any major economy, and aligns it with the pathways published by the Intergovernmental Panel on Climate Change, the IPCC, to meet the all-important 1.5 degrees Celsius goal. Then lastly, let's not forget the NPPF 2021, in respect of plan making and decision taking, says that the planning system should shape places in ways that contribute to radical reductions in greenhouse gas emissions. Let's look at a few current or pending planning decisions. The two I wanted to mention are both examples of the Secretary of State exercising his powers, including to call in for his own determination in the planning sphere to ensure that he retains direct control over controversial decisions that have climate change implications. In terms of the Cumbria appeal, that was heard by way of a 4-week public inquiry, which closed, I think, a fortnight ago, into the Cumbria deep coal mine. The appellant was claiming in that appeal that the development will be net zero compliant from day one, that there is a critical need for the coking coal that the mine would produce. It remains to be seen how long it will take for the Secretary of State to make a decision in that case. Notoriously, call-in decisions take quite some time. Who knows where we'll be in terms of the climate change landscape by then. Recent cases, the first one I have to mention, I can't not mention it, is the Supreme Court's judgment, Friends of the Earth Plan B, against the Secretary of State for Transport. This was the judgment which upheld the lawfulness of the airport's national policy statement at the end of last year, the court unanimously holding that in complying with the requirement in the Planning Act 2008 to explain how a national policy statement takes account of existing government policy on climate change, statements by MPs about commitment to the Paris Agreement did not fall within the scope of what the legislation means by government policy. There it was, in fact, no established government policy at the time of the NPS being published that was going beyond what was already reflected in the 2008 Act. And so furthermore, the government had taken the Paris Agreement into account anyway and the NPS required any future development consent application for the third runway to be assessed against the carbon reduction budgets in place at the time. Packham is the next case I want to talk about. This relates to when the government carried out the Oakavie review into whether to proceed with HS2. The Court of Appeal held in July 2020 the government did not fail. The government had not failed to consider the implications of the Paris Agreement and the Climate Change Act 2008, and noted the wide discretion that is given to the government in deciding which legislative and policy measures it wishes to put in place in order to achieve the net zero target. Transport Action Network Limited, this was a judicial review of the government's new Road Investment Strategy 2, the second part of a strategy providing for a number of different strategic road improvement schemes. It was again a claim that there'd been a failure to take into account the Paris Agreement, Climate Change Act and the carbon budgets. But on the facts, this was rejected, the judge finding that the net zero target had been taken into account as a material consideration. In Client Earth, this was a challenge to the grant of development consent for 2 gas-fired generating units, and it was claimed the Energy Policy Statement, EN1, required the decision maker to undertake a quantitative assessment of need. The Court of Appeal dismissed that interpretation, putting to bed some debate that was going on as to whether a promoter needs to quantify a project's particular contribution to satisfying the need for new energy infrastructure in any given case. It also held that in the balancing exercise that's required under NPS EN1 to determine whether the benefits would outweigh the impact on greenhouse gas emissions and any other impacts, the Secretary of State was entitled to regard the GHG impact as not being determinative in the balancing exercise. Vince and others against the Secretary of State. This was a claim issued last year against the Secretary of State for failing to review those energy NPSs in light of climate change policy and legislative changes. It was argued that the NPSs were now a decade old and were therefore out of date, and that a review was legally required in order to keep them up to date. The claim was resisted by the government, but ultimately has not proceeded to a substantive hearing because the Secretary of State has decided to consult on revised energy NPSs anyway. The claimants interpret this as a victory. They say that the change and the recent consultation that is now underway is a product of the litigation, whereas the government appears to be saying they were going to undertake the review anyway, and that it's not being prompted by the litigation. I suppose we'll never know which of those it is. Elliott Smith, finally, this is the last recent case I want to talk about. This is the claim of Mr. Elliott Smith, not Elliott Smith, the late American indie rock singer-songwriter, just in case any of you were confused. This was a claim against the domestic British-born emissions trading scheme, which replaced the EU emissions trading scheme after Brexit. It was challenged again. You'll be seeing a theme developing here. It was challenged for failing to take into account the Paris Agreement, but this was rejected on the facts. The court also had regard to the statutory purpose of an emissions trading scheme under Section 44 of the Planning Act 2008, namely to limit or encourage the limitation of activities, which the court regarded as being complied with by this particular scheme. Pending and future cases to keep an eye on, there are 3 I want to mention. First is a wide-ranging claim, a very wide-ranging claim that is brought by Plan B Earth, accusing the government for various reasons of failing to take sufficient practical and effective measures to comply with the Paris Agreement, the Climate Change Act 2008, and also a related claim that the government's perceived inaction in respect of climate change and measures to address climate change is constituting a breach of the claimant's human rights. Firstly, the right to life. Secondly, the right to their private and family life. And thirdly, there is a related discrimination claim as well. I understand from recent reports that the claim has been refused permission on the papers at first instance on the 4th of October, so last week, but that the claimants are in the process of renewing their application, which will then be considered by a judge in an oral hearing. So be interesting to see where that goes. The second one to watch is a claim, an anticipated claim by Good Law Project. They've been having a war of letters recently with the government over whether under Section 6 of the Planning Act 2008, there is a triggered obligation to review the poor old ANPS in light of climate change developments, including net zero. So just as the government thought that the airport's national policy statement had emerged unscathed from the litigation ending in the Supreme Court, there is another challenge in the offing. The government has publicly decided, by way of a letter to Good Law Project, that it has decided that it will not be reviewing the ANPS on the basis that although the changes such as net zero are significant and unforeseen, it would not be possible to conclude that the NPS would have been materially different had these circumstances been anticipated. I'm sure there'll be lots of people listening to me speak now who have views about whether that will stand up in court. It'll be interesting to see what the Good Law Project say in their claim. All we know from their website is that they expect to issue proceedings promptly. They obviously will need to take into account the time limit for judicial review claims. Lastly, Finch. This is a case that, as Dave mentioned, I was involved in the High Court in December of last year. This is a case where the judicial review was brought against the grant of planning permission by Surrey County Council for 4 new oil wells. The decision was challenged on the basis that the environmental impact assessment that was undertaken for the project did not assess the downstream or end use greenhouse gas emissions that were anticipated to arise from the combustion of the oil that was being produced by the development, typically by cars burning fuel. The High Court held that these impacts were not impacts of the development, whether direct or indirect, and so did not legally need to be assessed under the EIA regime. This is obviously quite an important issue about the proper scope of environmental impact assessment and will have implications going way beyond just oil extraction. And an appeal is being considered by the Court of Appeal, permissions being granted, and that will be heard in the middle of next month. So that's the last case that I wanted to talk about. And I suppose by way of concluding remarks, before we pass over to Jenny, I think it's fair to say from the cases that I've referred to that the government has had a reasonably successful time in the courts recently in climate change cases. Attempts to challenge the government's decision-making for failure to take into account climate change-related considerations have by and large failed. But the question will now be, if the government is saying and deciding all of the right things, having proper regard to the various duties imposed by the Climate Change Act and other legislation and policy, signing up to the ambitious world-leading carbon budgets, according to the CCC, will they be able to adhere to what they have committed to as we progress closer and closer to 2050? Thank you very much.
Thanks very much, Matthew. Good afternoon, everyone. No surprise to hear that I'll be speaking about air quality and how it fits into the Environment Bill. See if I can get. Oh, I'm having the same problem. Oops. Just moving my slides on. Oh, happened now. Takes a bit of warming up, I think. Yes, so my talk is going to fit into 2 parts, really. The first part will be how air quality fits into the bill and the specific provisions relating to air quality that the bill brings forward. And then the second part, a bit more general on relatively recent air quality news and litigation. So then first, the bill. To the left, sorry. Oh, thank you. Yes, how does it fit into the bill? Well, as I'm sure you all know, it's one of the 5 identified priority areas in clause 2 of the bill. And what's the consequence of that? Well, it means that the Secretary of State is required to bring forward regulations setting a long-term target in at least one matter within air quality. And one matter within is fairly vague, but the government has indicated its intention that with regard to air quality, the target that it's proposing to bring forward, or the long-term target it's proposing to bring forward, will be a population exposure reduction target in relation to fine particulate matter. And that is billed as being a more sophisticated target than simply a limit value, which can apply more widely than just the hotspots where a limit value may be breached. It's looking more qualitatively at how the pollution affects particular centres of population. That's the intention. And that target is a long-term target, which means it's more than 15 years. There's a separate, so separate from being one of the 5 priority areas and the targets related to that, there's a separate specific requirement under clause 3 to set a target in relation to fine particulate matter. And that was relatively broad-based in the bill as drafted, but recently, as amended by the House of Lords at the report stage, it's been prescribed to be a pretty tough target of less than 10 micrograms per metres cubed and to be achieved by 2030. The government was resisting that because they say that in order to bring it to that level, which is the level recommended by the World Health Organization, you would need measures such as a total ban on the burning of solid fuels within cities and a 50% reduction on traffic kilometres. So pretty wide-ranging radical measures would be required to meet that target. And for that reason, I suspect that won't survive the next stage of the bill. And instead, there will be a general requirement for consultation to bring in the target related to fine particulate matter. But that's the current state as drafted at the moment. So, of course, what's the relevance of these targets? Well, there is a duty in the Act on the Secretary of State to meet them. It's in clause 6, and then there's various reporting and reviewing requirements and duty to set interim targets. But of course, this is all only as good as the measures to implement and enforce such targets. In the previous regime, or the EU regime with the Air Quality Directive and the regulations, that's been pretty successful in the sense of the Client Earth litigation has been notably successful in enforcing the government's requirements to meet the nitrogen dioxide targets and their failure to do so. And I'll come back to that in a moment. But of course, this all depends on how the Office of Environmental Protection will, how independent they'll be and how rigorous they'll be. And I'm sure you heard a lot about that this morning. So, so that's the broad basis of how air quality fits in. There are then some more specific measures, provisions on air quality in the bill in Part 4, clauses 73 to 79. And those specific provisions fall into 4 broad categories. First are amendments to the local air quality management framework, which you'll be familiar with and I'll come back to in a moment. Second, some specific provisions on smoke control and fuel burning and the enforcement of those restrictions. Protection of pollinators from pesticides and provisions allowing the Secretary of State to require environmental recall of motor vehicles and related products. So first then, just considering the amendments to the local air quality management framework, that I'm sure you'll be aware is set out in Part 4 of the Environment Act 1995. And it has the familiar requirements for a national air quality strategy, air quality management areas and local air quality action plans. The amendments increase sort of transparency and rigour on the Secretary of State by requiring Secretary of State to review the National Air Quality Strategy within 12 months of the implementation of this clause, and to report, and to review it thereafter every 5 years, and to report on progress against the strategy to Parliament annually. There's also then requirements for increased cooperation at a local level, and particularly there's a requirement for local authorities to identify if they are in breach of limit values, and if they have an air quality management plan, to identify sources of emissions that are causing those exceedances, to identify other public bodies who may be contributing to those exceedances, such as neighbouring local authorities or other executive agencies or other public bodies, so presumably the Environment Agency and the like. So local authority is required to identify those, and then when they are identified, they are named a partner body, I think, a partner organisation, and then there are requirements on those bodies to cooperate in air quality management areas and the plans relating to that. So it's quite a complicated but increased level of requirements on bodies to help local authorities meet their targets. So that's the local air quality management framework. Then, as I said, there's smoke control and enforcement measures, which consist of amendments to the Clean Air Act 1993. There's provisions for imposing financial penalties for the emission of smoke in smoke control areas in England. And the change there is to make those civil penalties, which remove the requirement for statutory defences and enable enforcement to be quicker. There is a provision for appeal against such penalties, but the idea is that they can be imposed at the outset much easier, and the normal sort of criminal standard of proof isn't required. And the penalties at the moment are set at between £175 and £350 for an infringement of those requirements. There's then provisions relating to creation of offences related to sale and acquisition of types of solid fuel. And of course, this will all become very important if if the targets relating to fine particulate matter are brought into effect, because domestic burning of solid fuel has been identified as one of the main areas of difficulty in meeting those targets. And those offences those provisions enable offences to be created on those selling fuel and those buying fuel with a reasonable intention of using it in a smoke control area or a prohibited chimney and the like. There's then also provision about inland water vessels. So having your wood burning stove on a canal boat in the middle of London, that might be a problem. And there's provisions for applying smoke control orders in relation to those. And then there's specific provisions in relation to Wales, related provisions in relation to fuels and fireplaces. Third area of specific air quality provision, not necessarily what you immediately think of as air quality, but I presume they're included in this section because pesticides are airborne, I expect. And they do, there's been quite a lot of news about the adverse effect that they have on honeybees and other pollinators, and of course how that affects the ecosystem much more widely. So this provision is a ban on competent authorities. Competent authority in England is the Secretary of State. So ban on the Secretary of State from authorising pesticides or pesticide products for use unless satisfied that there's no significant short-term effect and no long-term negative effect on the health of honeybees or wild pollinator populations. And there's quite stringent requirements on how a Secretary of State is able to authorise use of such pesticides or any pesticides. Before doing so, there must be a publication of a pollinator risk assessment report to be published by an expert body. And it's quite interesting that that expert body is specifically required not to have vested interests and must be independently appointed. And there's really quite wide-ranging requirements for consultation, both public consultation and consultation of other environmental bodies. And I think it's a minimum of 3 months allowed for consultation unless there's an emergency measure, which is 4 weeks. So quite strict requirements on authorisation of future pesticides, which I'm sure will be welcomed by a lot of environmental pressure groups. And then lastly, in this section, there's some provisions about the environmental recall of motor vehicles. Presumably this is all on the back of the defeat devices scandals over the last few years. There's provisions for the Secretary of State to make regulations enabling the recall, or enabling an order requiring manufacturers and distributors to recall relevant products that do not meet environmental standards. Those relevant products are basically cars, other vehicles, and their component parts and engine. The regulation, the power includes the facility to require compensation to be paid to purchasers and the possibility of appeal. And also, interestingly, gives the Secretary of State powers to enter premises of those manufacturers and distributors and require documents. So presumably that's all, again, intended to prevent that sort of scandal from happening again. So that's the bill in a nutshell, where we are at the moment with the bill in relation to air quality. And then I thought I'd just go over a few recent developments in the news and in litigation. And I set out there what I'm going to deal with, the coroner's report in relation to the very tragic case of Ella kissing Deborah, the relatively recent CJEU decision on the back of the Client Earth litigation, and then some recent domestic litigation relevant to air quality. So starting then with the coroner's report in relation to the case of Ella. And she was a 8-year-old girl who suffered severe asthma in February 2013. She died, and the cause of death was recorded as respiratory failure. And then a couple of years later, there was a leading expert on asthma and air pollution who identified that the type and severity of her illness was directly linked to exposure to air pollution, and specifically to the fine particulate matter and the nitrogen dioxide emissions from transport, largely, I think. This was particularly pertinent because she lived only 25 metres from the South Circular Road, where there was persistent exceedances of EU limits in relation to those particular air pollutants. And you probably remember the news, but in December last year, a coroner held a 10-day inquest, and at the end of that concluded that a failure to reduce air pollution contributed to her death, as did a failure to provide her mother with information about the effects of air pollution. I think that was a pretty landmark ruling. It's the first time that a coroner's report has identified those failings as contributing to a person's death. The coroner's report called for the government to bring in a reduction in the fine particulate matter targets and to bring in requirements about air quality information. And the response to that was, the government response to that came out in June this year, and they said that they were investing another £6 million, providing to local authorities so they could implement measures for information and awareness. And of course, they cited what they're intending to do in relation to the Environment Bill, and specifically consulting and reducing the fine particulate matter targets. And the intention is that those are brought in by October 2022. The next piece of news is in March this year, the European Commission, brought a case against the UK in the CJEU for systematically and persistently exceeding the annual limit for nitrogen dioxide, as well as the hourly limit value for NO2 in Greater London. And this was on the back of the series of Client Earth litigation, where you'll recall Client Earth brought various cases requiring the government, and succeeding to require the government, to basically clean up its act and bring in more stringent and better, more rigorous plans for seeking to meet those targets. The CJEU was pretty scathing about the UK in March, and dismissed the defences that were put up. Basically said that just by the fact that the limit values were exceeded so persistently and to such a high degree meant that the measures that the UK were implementing were just not adequate, not rigorous enough. The fact that other countries might be in breach was irrelevant and didn't mitigate the UK's actions. And the CJU would not allow the UK to pass the buck back to the EU on the basis that this was all caused by the Volkswagen cheap devices scandal. CJU said that's not the only cause, and in any event, that's not an answer. You still need to meet the targets and meet the limit values. So that was, again, a pretty good demonstration of how the previous regime that's now effectively gone, although obviously the directive and the regulations in relation to NO2 still apply because they're retained in EU law, but the framework for enforcing that, the Commission and the CJEU, it is obviously now gone effectively, and it'd be interesting to see how the OEP steps into the breach in relation to those that sort of enforcement. Then, yes, I just wanted to touch on some recent litigation relevant to air quality. Now, this is a case, it's not strictly an air quality case, or it's not even at all an air quality case, but it does have some effects relating to air quality. It was a challenge by the taxi drivers body to the London Street Space Plan, and that was a plan and guidance implemented by TfL during the pandemic, with the first few months of the pandemic, seeking to remove vehicles from bus lanes, largely, including removing taxis from bus lanes, increasing road space for cycling and walking, all with the intention of enabling social distancing during the pandemic and preventing private vehicles stepping into the breach to enable social distancing. Because, of course, that was when people were worried about using public transport, that was the natural, potentially inevitable adverse consequence. The challenge was brought on a number of grounds, and sort of behind all this was, I think, the fact that the Mayor of London and TfL had announced the London Street Space Plan, not just in relation to dealing with the pandemic and social distancing, but the longer term agenda of lowering emissions, having zero net emissions, and dealing with air quality, basically. And that was, I think, part of what influenced the High Court judge, Mrs. Justice Lang, to quash the plan on the basis that it was effectively an ulterior, she saw it as a slightly ulterior motive behind bringing in these emergency measures to expedite the sort of zero emissions targets. And found a breach of legitimate expectation on the behalf of the taxi drivers in relation to their use of bus lanes, contrary to their rights to property under the human rights to property under Article 1 of the First Protocol, and irrationality in the decision making. So, as I said, that was quite a startling decision in that the whole London Street Space Plan was quashed by Mrs. Justice Lang in the High Court. That subsequently has been overturned by the Court of Appeal, who have been much more benign about Transport for London's process during the pandemic, basically, and giving them much more leeway in the measures they took to deal with the pandemic, and saying, well, the fact that there were public pronouncements, which might have also included things like air quality, that doesn't detract from what was the main thrust of what they were trying to do and the emergency nature of what they were trying to do. And basically had a much lower level of rigour from the court, and gave them a much wider margin of appreciation effectively as to how they were going to deal with the pandemic. So that quashing has been overturned by the Court of Appeal. Next case I want to talk about is a little bit older. It's a Court of Appeal case from, I think, 2019, actually. But it's really interesting because it does show the power of the air quality litigation, the Client Earth air quality litigation. Again, in fact, it was a challenge by Gladman to the dismissal of 2 appeals for residential developments in air quality management areas. The inspector who dismissed those appeals, and so didn't allow them to go ahead, those residential developments, found that the air quality limit values would be exceeded in the location of those residential developments, and took into account the NPPF, the National Planning Policy Framework, which requires measures or requires developments to assist in meeting limit values, and requires to take into account and comply with local air quality action plans. the developers' response to that was, well, the government's bringing in action plans as a response to the client Earth litigation. They're dealing with all these problems. They know they've got to deal with these problems. They know they've got to meet the nitrogen dioxide limit values. That's what they're going to do. That's part of their regime. That's effectively a polluting or permitting regime, which you should assume is going to be met. Because in planning generally and in the NPPF, there's a requirement that polluting and permitting regimes in relation to other environmental matters are assumed to be met and shouldn't be a reason for refusing planning permission. The court held, and this was upheld by the Court of Appeal, that the sort of measures in the air quality plans to meet the limit values, those are not a separate permitting or polluting regime. So the inspector doesn't have to assume that those targets are going to be met and can take his own view about whether they will be met or what effect they'll have. And at the time of the decision, the inspector had no knowledge of what the measures were going to be that the government was going to put in place, and no knowledge of how they were going to be effective. So didn't assume anything about what they would achieve. And the inspector also found that the mitigation proposed by the developer was effectively token, in the sense it was contributions, financial contributions, relating to things like charging, vehicle charging, electric vehicle charging points, and green measures to encourage use of cycles and pedestrian transport, etc. But he said, well, I've got no real evidence that those will actually have any concrete results or reduce the use of private petrol and diesel vehicles or reduce emissions. So didn't put much weight on those and dismissed the appeals. Another point raised by the developer was, well, shouldn't you have thought about a Grampian condition? The inspector should have said, well, everything else about the development is acceptable. If it doesn't meet these air quality measures at the moment, why don't I put a condition on it saying development cannot be commenced until a suitable scheme for dealing with air quality has been approved and put in place. That Grampian condition was not put forward during the appeal, and the court held that the inspector was under no duty to come up with it as a possible solution himself. So dismissed the appeal, and the development was thwarted. The two developments were thwarted on that basis. So quite an interesting example of how air quality, the background of those limit values, the policy in the NPPF and the background of the client Earth litigation has given some strength to inspectors in refusing developments on air quality grounds. And then lastly, this is a very recent case on air quality, 16th of September, so only a few weeks ago. And it was a case against the Environment Agency for their failure to properly regulate the emissions from a landfill site. Concerned a 5-year-old boy with very severe respiratory problems who was exposed to hydrogen sulfide emissions from that site. And there was expert evidence saying that this was an inevitable precursor to serious illness that would reduce his life expectancy. So it's a very, very serious case. The High Court, Mr. Justice Fordham, was very sympathetic to that case and to the scientific information that's put forward about Matthew's condition. And he held that the Environment Agency's positive operational duties were triggered under the Human Rights Act and the Convention, Article 2 and Article 8, which are the right to life and the right to respect for private and family life. So he certainly considered they were triggered. Slightly odd outcome, because he did also hold that there was no current breach of those duties by the Environment Agency, but declared that in order to comply with legal obligations in relation to that, the Environment Agency was required to implement recommendations given by Public Health England in order to reduce off-site odours and daily hydrogen sulfide concentrations to specific levels in order to ameliorate the effect both on Matthew but also on the community. That was a formal declaration by the court, and whilst the claimant wasn't successful in achieving an order that the EA had breached its duties, they did get that declaration, and as a result did get costs, or at least a portion of their costs in relation to bringing that litigation. I think really the judge was just so shocked by the effect of those emissions on that community that felt was motivated to do something in relation to that. So again, perhaps just as a reflection, I mean, overall, I think air quality in terms of litigation against the government and local authorities has had more effect than climate change, reflecting what Matthew said. And I think that's me. So thank you very much.
Thank you. Thank you very much, Shelley. That last case of Richard's, I suspect is going to have some long-term implications, because I think it's the first case where there's been a finding of positive operational duties on the Environment Agency and a requirement, the court effectively saying what you've got to do for the future. It's pretty hard-hitting stuff if it stands, if it goes to the Court of Appeal. All of us will have seen situations where local residents are upset at the failure of the EA or Natural England to enforce, and the Natural England says it's decided not to for X and Y reasons. Now, obviously, that was a pretty extreme case, Richards, but the scope for effectively forcing NE and EA to act may be the dam might have broken a little bit on that. I've only got one or two questions so far, but I wanted to raise one issue that's cropped up in the other sessions, and that's effectively how you deal with assertions of progress and policy aspirations and policy promises and so on, and graphs that look like they're going in the right direction, all that sort of thing, and how you marry that up with actual delivery and actual policy proposals, which is the point that Matthew raised right at the end of his talk. Obviously, this is being raised in the Plan B. I think their bottom line is that the trajectories to get to net zero require massive steps, and it's all promise at the moment and no substance. That's the bottom line. Now, that didn't get permission, but it has struck some of us over the years that as we've looked at the climate change reports as they come through, you see the graphs each year, they get steeper graphs, the timeline gets narrower to 2050, the graphs get steeper, the low-hanging fruit is already being taken. And Matthew, just at what point will the courts get involved and say, hang on, there's a disconnect, a serious disconnect between the promise and the delivery?
Well, as I said, Dave, to date, the courts have expressed, in my view, quite a lot of reluctance to question what the government is saying, and indeed also the CCC, as to the realistic nature of the proposals and the commitments that they're adhering to. And I think that for the time being, whilst the government is still able to say that we're doing everything that's consistent with achieving net zero, the courts will continue to display a degree of deference to that expertise. However, as we proceed closer and closer to 2050, and if demonstrable evidence comes to light that there is an inability to meet the various interim carbon budgets, I think that is where the government's going to start getting into hot water. But I think it's going to need something pretty concrete. And I think the struggle that the Plan B claim has at the moment is that there has been an awful lot of evidence coming to light that is seeking to dispute the government's position. But the courts don't seem yet to be prepared to weigh into that debate.
I mean, quite a lot of the case law that you see is the court saying this is all a matter of scientific judgment, not for us.
Quite.
And you have to get to a point where you can say something contrary to that and really get behind that yet. We've just got a question from the floor here. Just getting a microphone so people remotely can hear.
Thanks. Joe Newbegin, Government Legal Department. Just wanted to ask a question that followed from that about the domestic court's reluctance to get involved in kind of climate change cases of this nature, because we've been rumbling on for a while the Portuguese youth climate change case, which we were hearing about a couple of years ago, has got a bit quiet on that front. I just wondered whether in any other forum there were going to be other cases arguing similar grounds that perhaps would be more likely to take a more adventurous position.
More adventurous position.
Yeah.
Well, there have been, I mean, I must confess, I'm not an expert in in other jurisdictions, but that there have been instances such as the gender litigation, which has succeeded in respect of climate change. That's, I think, a slightly different situation because they were relying on the constitution and also the fact that there wasn't a dualist system. So they're able to directly rely on, I think, the Paris Agreement in that case. Whether that was the reason why the litigation was more successful, I don't know, I must confess. I'm also not familiar with the Portuguese example that you referred to. But...
Sorry, I apologise. I was just fishing for any update from the international case law. Is that...
No, I mean, a lot of these cases, certainly in America, a lot of the cases do a trawl of international case law to show where different laws are going. So far, that hasn't got much traction in the UK.
Thanks. Melinda Janke. I'm currently doing climate change litigation. Matthew, I wondered if you could shed a little light on how the courts in England are making their decisions, because it's quite clear that the UK is not a climate leader. It's one of the countries that has emitted the most greenhouse gases, and to turn around and say, well, we're leading because we're cutting greenhouse gases, actually is a statement that makes no sense. The countries that are leading are the ones that are, for example, like Guyana, which is a carbon sink, and so is actually taking greenhouse gas out of the atmosphere. And I'm wondering whether you could shed light on this, because it sounds as though the courts are looking at government statements, government policy, government, for want of a better word, propaganda, rather than looking at the science, which is coming out of the IPCC, which says that basically we need to change right now, or looking at, just things coming out of the industry, such as the International Energy Agency, which says that there's no reason to have new oil and gas now. To what extent is that kind of information or that fact base brought before the courts?
Well, I think as Dave said earlier, I mean, it's a very, very good question. But as Dave mentioned earlier, the courts in this jurisdiction are extremely reluctant to descend into the scientific arena, you can call it that. There are obviously a number of different claims being made, both by experts for the government and also those who are taking a different view to the government. And a judge sitting in the position of somebody who may well be very legally qualified but does not express any expertise as a scientist, in what circumstances are they going to be able to gainsay what the government's expert advice is? And I think the other difficulty that climate change legislation has, which I think is different from the air quality context, is the lack of really hard-edged teeth in the legislation itself, to actually give something for the court to lock into. It's much easier, I think, for the government to demonstrate compliance with the obligations that they're under, especially because we have a time scale up to 2050, which the government can always say, well, we are complying with our obligations, and we have all of this time to do so. So I don't know whether that's something that needs to be addressed in the legislation to try and impose greater restrictions on the government at the interim stages. But I think that's what I would say in response to your question.
It sounds like we're on different planets, because there is a context that the courts don't seem to be taking into account. We don't have to prove gravity when we go to court. No one would seriously argue it doesn't exist, any more than one can seriously argue now that the climate system is not breaking down, or that the ocean is not becoming more acid, or that sea level isn't rising. And I suppose it's that gap that bothers me.
Yeah, I mean, that's the disconnect question. At what point does the court start saying, "Oh, hang on, it's all very well having this policy, but where's the connect with the real world?"
What planet are we on? Yeah, judges.
Well, we'll see what happens with the Plan B litigation of that commission. And so I should just mention, actually, in I think in the first Heathrow case, the first runway 3 case, I think Lord Carnwath did say that if you could demonstrate there was a disconnect, that might be a ground for JR. So if there was a disconnect between the promise and the delivery, that might be a ground for JR. He said the facts of the case haven't got to that stage yet, or something like that.
Hi, David. So interesting, the climate litigation, but I want to talk about air quality, because air quality is fascinating. Thank you, Jenny, for your presentation. I guess I had a question which is less about the courts and about what the architecture of the Environment Bill can do to support air quality targets. And you mentioned the PM 2.5 air quality target, which after the House of Lords amendments, now with the reference to WHO guidelines, would be 5 micrograms so far as possible after the new guidelines, which is very, very low. But even if you had a very ambitious target, who's responsible for delivering it? I mean, you might end up in a court ultimately, but who's responsible for delivering it? Because at the moment, the Act is still pushing with a bigger LAQM kind of framework, the responsibility onto local authorities. But at the same time, a minister is responsible for achieving those targets. And there's always this disconnect between the collective ministerial responsibility and the local. And I wonder if you think there's anything in the bill that helps marry those two up, or actually will do the work of not ending up at a point where by the time you get to 2030, it hasn't, or the report date, whatever it might be, the target hasn't been met. Do you think there's anything useful in the bill? I have thoughts, but I'm kind of interested.
Well, obviously, there's clause 6, which directly requires the Secretary of State to meet the targets. But
there's clause 7.
Yes, exactly. And I mean, there are some useful things. I don't think they're a panacea by any means, but there are things like requiring reporting, requiring interim targets, requiring reviews, and those are all potentially embarrassing for the government if they report to Parliament and say nothing's changed or it's got worse. You know, they're all things which I would imagine would exert some sort of pressure, and if it's on a no news day, it could potentially have quite a significant effect. But obviously, if it's not, then it might not. You know, those are all political outcomes, which I think the bill does go some way to addressing. And if you remember, I think was it one of the client Earth cases, judgments, did say that it wasn't enough for the government to pass the buck to local authorities, wasn't it, in relation to meeting those targets. But of course, again, we're in a different regime, and it's how that different regime will work in relation to not allowing the Secretary of State to pass the buck. So, yeah, I mean, I think there are some small steps that have been made, but it's by no means a full result.
What about the OEP?
Yeah, well, I mean,
did you have a debate on that this morning?
We did, yeah.
We probably haven't got time to get into the whole detail of that. We all have our own views as to the efficacy of that. Can I just ask, whilst we're on air quality, actually, Helen, who's watching us remotely, has asked about the relative success of air quality litigation seems to have hung on EU directives. And I think also, in the light of the question earlier, an actual, you have to do it now, or as soon as you can be practical, rather than 2050 for climate change and so on. But the question is, to what extent does the Environment Bill make it more or less difficult to bring such challenges?
Well, I mean, again, it's partly about the targets. So the fact that there will be potentially more stringent targets gives you that benchmark, and those. And as we've said, it is a hard-edged result. You can check the monitor at a particular street and see whether the target's being met over the course of a year or an hour. And if that's persistent breaches, then it provides the background to the climate success. So the concern is that the targets can be rowed back on, I think, and there are provisions for reducing the targets. And of course, you just don't have the oversight of the Commission and the CJEU, who's independent of the UK, and that's the problem.
In fact, we just be asked the question: what's the likelihood that air quality targets could be ruled back if the government finds it too difficult to deal with?
Well, yes, and exactly.
Yeah. Okay, I think we've got time for another couple of questions, if anyone else in the room. Or now, Matthew, this is in respect of devolved powers across the UK. Obviously, in different jurisdictions, different speed of coming up with their own climate. Right? The question relates specifically to Northern Ireland, which is way behind. And how does that impact upon Britain's ability to comply with its obligations and the net zero?
Well, yes, you're right, Dave. Northern Ireland, there is a gaping hole in the climate change carbon budgeting regime for the UK in Northern Ireland, because although notionally they're subject to the Climate Change Act 2008, because it's a devolved power. None of the carbon budgets in the UK Act are enforceable in Northern Ireland. And it's been a subject of some discussion, as you can imagine, in Northern Ireland. That the CCC have recently been in Northern Ireland and have been saying to ministers that they're way behind the rest of the UK in terms of dealing with climate change. There is a bill before Stormont which is seeking to introduce, for the first time in Northern Ireland, a legally binding net zero target for Northern Ireland. There are various different competing legislative arrangements. I think the Green Party in Northern Ireland are looking for net zero by 2045, so 5 years faster than the rest of the UK. But the CCC have said, we only need you to do 82%, so not net zero, by 2050. And that's to reflect the fact that once you factor in the rest of the UK's contributions, the net outcome will enable the UK to get to net zero by 2050, if that makes sense. So, and I think the recognition that the CCC have got, and I think it's a good one, is that you need to take into account the ability of governments to respond in the time available, bearing in mind the cost implications. So they regard Northern Ireland as, primarily the issue in Northern Ireland is the agricultural sector. Put in a slightly vulgar way, it's farting cows, methane, and it's a major issue in Northern Ireland. The agricultural system needs modernising. It's quite out of date in terms of the technology. Green technology isn't something that's really featured in Northern Ireland in the same way as in other countries. So the objective for politicians is to try and implement the new carbon budgeting regime through the bill, but at the same time ensure that there's sufficient investment in clean agricultural practices so that those measures can actually be implemented without ruining the farming sector. And the problem at the moment is politically it's a hot potato, because you have DUP and various other parties who are saying this is disastrous for our farmers. But then you have the Green Party and various other parties who are saying, but the climate crisis has to take priority first and foremost. So I don't know how it's going to end. It's very contentious at the moment. The Agricultural Minister, Edwin Poots, I think just a couple of days was talking about how disastrous the climate bill is going to be. One of the other interesting things in the bill at the moment, query whether it will survive, is a guaranteed, a legal guarantee of non-regression from all the existing climate and environmental protections that are in place at the end of the Brexit transition period, which I think it would be interesting to see whether that stays in the bill. But as to whether it's slowing down overall, I think we're still at a stage where the contribution of Northern Ireland is still small enough that it's a salvageable situation by 2050, but we'll need to wait and see.
I think we've just got time for one final question. One from the room and then one from my laptop here.
Thanks, David, Matthew and Jenny. Some insightful comments there. I'm working on a project, Steve McNabb, sorry. Matthew mentioned the Vince case and that the NPS energy planning policy statements are now in consultation. There's a live application on at the moment in the town and country planning regime for a power station. It's an energy from waste facility which will have emissions significantly better than the baseline of export and landfill. Just wondering, what weight should the local authority be giving to the NPS in consultation, which has got some really interesting points in it, such that the Secretary of State shouldn't assess the individual carbon budget of the application. That will be dealt with at a policy and a national level, and recognising that there will be residual emissions from energy infrastructure of this type. So just any comments on the weight that should be given and the relevance to a town and country planning decision for that?
It's a good question. I mean, at this point, given that the consultation is still ongoing, and there are no doubt going to be a multitude of objections to whatever's being proposed. I suspect that local authorities at this point in time determining such an application would only be able to give very limited weight to the proposals in place. That's not to say that there might be some mileage in seeking to delay or defer applications until the amendments to the Energy NPS have been fully consulted upon. But the problem with that is I don't know what is currently being envisaged in the amended versions by way of transitional provisions. So it may well be that any application for planning permission that has already been submitted is subject to the NPSs as they stand as of the 2011 versions. I haven't checked to see what the transitional provisions are, but I'd be very surprised if there weren't some.
And the final question is a remote one, which asks about the implications of the Richards case and whether it's possible in a JR context to ask for effectively declaratory relief as to future action. That I think I said as soon as Jenny sat down, that seemed to me to be a pretty fundamental departure from what I previously understood was the role of the courts, but quite an important development from Mr. Justice Wharton. The context in Richards was that there was a really strong medical evidence. It was a pretty extreme case, which was held to engage both Article 2 and Article 8. So Article 8 alone may or may not have been enough, but engaging Article 2 was enough to say the court has got to act under the Human Rights Act. Has got to act. It's not only a duty not to stop things happening, it's also a duty to ensure that positive things do happen. And that was the logic there. Actually requiring, as a result of the court order, requiring a body to do something in the future is quite a big ask, I think, in 99% of cases. But the way I play this normally is either by building up the storyline, failure to do something for X or Y pre-action protocol letters over a period of 6 months or so, and then issuing, and just saying that they had the duty back then, they didn't do it, they're still not doing it. You should declare their failure to comply with their duties. That's the first one. The second approach is reserved. The sort of Richards approach is reserved for the North Street case.
I think that's right. Yeah, I think it's not. You're not going to be able to bring that on a sort of technical point. It's you're going to need a pretty strong context and pretty severe implications on the community or on the claimant to motivate the court to take that sort of action.
So you need to put that into that case.
Yeah.
Okay, I think that's time up. I think I'm getting the nod from the back. Thank you very much for joining us. I think there's teas and coffees for those in the room. And I think the next session starting in 15 minutes or so with Tim Mould. Thank you very much.
Welcome back, everybody, and to those who are attending remotely. My name is Tim Mould. I'm chairing the final session of today's conference, where we turn our attention to a number of the practical provisions set out in the Environment Bill, particularly those concerned with the issue of biodiversity net gain and how that is to be achieved through the development process. Also, the question of conservation covenants. Both of those are legislative initiatives that have long since formed part of emerging government policy on the environment and on the role that planning and development play in securing the safeguard and the improvement in the nation's biodiversity, protection of species and habitats and so forth. But they are finally at least coming to some sort of legislative settlement. We shall, of course, see how the legislation that, assuming it is passed, broadly its current form, having been brought into law, how that translates into practical achievement. And that, no doubt, will be one of the questions that, one of the topics that your speakers over the next few moments will want to focus on. So let me turn to the speakers. First of all, we have Richard Turney of these chambers. He practices in planning, environmental and public law, advises and represents all levels of government, developers, non-governmental organisations and individuals. He's a member of the Attorney General's A panel of the Council. His recent work has included advising government on the incorporation of net gain requirements for nationally significant infrastructure projects. Then we have, I'm very pleased to be joined by Dominic Woodfield of Bioscan. Dominic is the Managing Director of Bioscan UK Limited, one of the United Kingdom's longest established applied ecological consultancies. His expertise covers a broad spectrum from technical proficiency in botany, ornithology and protected species through to environmental planning, legal compliance, environmental impact assessment, habitats regulation assessment and expert witness work. Richard and Dominic are going to focus on the provisions for biodiversity net gain. Richard, I think, focusing on the legislation and Dominic on practical implementation. And then we are going to hear from David Elvin, QC. David, as many of you will know, one of the leading practitioners in the field of environmental law, certainly for the past 25 years or so, David, of course, has been involved in many of the leading cases on in this field, and I'm sure he will, don't mind me saying, also has advised extensively both government, non-governmental organisations, statutory consultative bodies, and of course, last but by no means least, developers, those in the property sector in relation to environmental matters. So a trio of highly experienced and expert speakers. Before I hand over, I think firstly to Richard, the thing I'm particularly interested in relation to biodiversity net gain is how it is going to be achieved in practice, how these arrangements are going to deliver genuine and visible improvement in nature conservation in this country. And that, of course, turns ultimately on resourcing the organisations, local authorities and others who have to regulate and to manage delivery. And I'd be interested to hear what speakers have to say about that. One question which has vexed practitioners thinking forward, particularly in relation to large infrastructure, where a question of positive purchase of land is important to today, is whether, when matters are put to the test, whether the need for land for the achievement of biodiversity is going to be seen as a justification for positive purchase. And one might, for example, have regard to provisions of Section 226 of the Planning Act 1990, which provide for positive purchase powers to be taken for the purposes of the planning of the area. Is that an example of the kind of power that might be brought to bear? And will Secretary of State, will central government support those authorities if, for example, they choose to rent that power, or to make use of the to achieve the objectives, make use of resources that are provided to them through the development process in order to realise the objectives which this Act, when it comes into force, is designed to provide for. That's just one question, I think an important question, and I shall leave that one ringing and hand over without further ado
Thank you very much, Tim. So I'm going to talk on net gain in the environment bill and give perhaps the boring bits of the biodiversity net gain talk. Dominic can tell you the interesting things about how this actually works in practice. Just a quick audit of where we are with net gain. We have the environment bill, heard about already today. Obviously, it's progress long, although perhaps coming to an end with third reading in the House of Lords this week. There's already hints of net gain in policy in the NPPF that sets out some of those provisions. In the planning practice guidance, the natural environment section, which was updated earlier this year and has quite a lot about net gain in it. And in national policy statements for nationally significant infrastructure projects, and in particular in the draft national policy statements that are currently being consulted on, there's more and more emphasis on the concept of delivering net gain. But I'm going to focus today on the bill because that's the main area of interest. And in the current numbering, clauses 99 to 102, schedules 14 and 50 make provision for biodiversity gain. And effectively, you need to look to the schedules to make sense of any of this. Schedule 14 inserts a new section into the Town and Country Planning Act and a new schedule into the Town and Country Planning Act. And Schedule 15 amends the Planning Act 2008. So I'm going to deal firstly with planning permission under the 1990 Act, the normal route to consent. The substantive provisions will be a new Schedule 7A of the Town and Country Planning Act 1990, which is for biodiversity gain in England. And the mechanism is to provide that all planning permissions are subject to a condition, which requires the submission and approval of the biodiversity gain plan. The first observation I've made is, of course, generally conditions are a matter for local planning authority, and I think it's only the time limit condition that the Act already makes provision for other conditions that are mandatory for grants of planning permission. So it's a novel mechanism. What is the biodiversity gain plan? Well, this important document is going to have to explain steps taken to minimise adverse effects, the pre-development biodiversity value, the post-development biodiversity value on the site, any registered off-site gain, any purchased biodiversity credits, and any other matters that may or may not be prescribed. And this is the first place that I'll comment. A lot of the detail is still to be seen because regulations will have to be made on certain issues, may be made on issues such as this, to prescribe other things that will be in a biodiversity gain plan. And then there's a decision-making provision, which says that the local planning authority, as will normally be the case, may only approve the biodiversity gain plan if it's satisfied, and then it's got to look at the component parts. The pre and post development value is correct, or perhaps more accurately, the pre-development value is correct, and the post-development value that's assessed is correct, or the post-development value would be better than assessed. Any off-site gain has been allocated to the development, so you can show that you have secured any off-site provision and that the assessment of that gain is correct. Any credits that are relied on have been purchased, so you can show that they've been obtained, and then the biodiversity gain objective has been met. And this is a sort of substantive test. So you've got your assessment correct, you've shown that it's all in line with what you put forward in your plan, but then have you met the objective? And broadly speaking, I'll come on to the detail, broadly speaking, the objective is 10% net gain. Again, there's a regulation making power, so we may see more detail as to what the decision maker has to take into account. So the biodiversity gain objective, and as usual with parliamentary drafting, to try and provide a precise meaning, it uses lots of words. It is met in relation to development for which planning permission is granted if the value attributable to the development exceeds the pre-development biodiversity value of the on-site habitat by at least the relevant percentage. And the value is post-development value on-site, any registered off-site gain, and any credits that are purchased. We've got those three components for any assessment of value. The relevant percentage is 10%, so that's the figure that everyone is focusing on, 10% net gain. The value is calculated by reference to the metric. Dominic will say a bit more about the metric, which is published by the Secretary of State. There's various other details is provided for establishing the date that the pre-development biodiversity value is to be fixed at, to ensure that activities aren't carried out to reduce that value. The post-development value is the projected value at the time the development is completed, and value is what can be secured for at least 30 years. Again, we'll come on to talk about this with other speakers, conservation covenants, and the practical implication of there being a 30-year time frame for showing net gain. Off-site gains, they can be counted as long as the enhancement in question is required under either a planning obligation or a conservation covenant, that it's recorded in the Biodiversity Gain register, and of course that it's attributed to the development in question. Various exceptions, and I think it's fair to say we don't know the detail of some of these because again there's regulation making power, but it doesn't apply to planning permission grants under development order granted by a development order. Urgent Crown development is excluded. Certain other developments, if specified by the Secretary of State in regulations. Then there's provision likely to be made in respect of excluding irreplaceable habitat from the assessment. And then modification there's potentially modification by regulation for phase developments, schemes which comprise a number of phases, and for retrospective planning permissions. And again, the devil will be in the detail for those. Credits then, very briefly, provided for in the bill. The Secretary of State, again, a regulation making power, can make arrangements for the use of credits to meet the gain objective, including the price to be paid, and the payments can be used to carry out works, purchase land, or to administer arrangements. So a whole mechanism of credits is anticipated. It certainly is already being looked at by lots of people. But again, the detail, the machinery of that, the circumstances in which those are going to be purchased, the price for those credits is a matter that's got to come out through regulations and then through practice itself. And then briefly on nationally significant infrastructure projects. So these amendments came in to the bill, came in earlier this year, following the Scotford review, which said to include NSIPs in the Biodiversity Net Gain requirement. The provision anticipates that the changes will be made outside of national policy statements through a biodiversity gain statement. And importantly, this is all going to be dealt with by a policy document, biodiversity gain statement, and not by regulations. The gain statement will give a percentage for each type of project or types of project and specify the manner in which that will be met. So it could be 10%, but we don't know. It could be more than 10%. And it could be a biodiversity gain statement for a whole range of nationally significant infrastructure projects, or you could see a biodiversity gain statement for railways or for ports. And we'll have to see the detail of that. And obviously, the complexity there is multiple different secretaries of state who may take different approaches. And then there's a change to the determination provisions to give effect to the gain statements. So drawing that all together, just some conclusions on the architecture of the bill before Dominic goes on and talks about the more interesting substance and how it might take effect. I think it's a fairly radical change to the planning system. I think there's no doubt about that. It's imposing a substantive requirement on the determination of all applications and a substantive outcome for those applications. Of course, at present, there are very few areas in which the law prescribes how an application is going to end up. And it does so, or will do so, in respect to net gain. The regulation is going to be absolutely key to various aspects. And I just say beware the lessons of SIL, because I think the SIL regime is a good example of where some quite broad statutory principles laid down and then the most labyrinthine mechanism in the regulations for understanding it. Those regulations have been repeatedly amended, and they still, in some places, make little sense. So beware those lessons. We don't know what these regulations will look like. For NSIPs, the biodiversity gain statements will serve a lot of the purposes of the regulations under the changes to the Town and Country Planning Act. So there's potentially a lot of detail in those about how you go about calculating net gain and approaching the whole topic. And ultimately, the substantive impact of developments will, in my view, turn on the application of the metric, the availability of off-site habitats, and pricing of credits, because either the developer will be able to show net gain on site, or they'll have to look for off-site habitat and say they sort of find something that's available to them, or they'll have to find credits that they can buy. So that's the way in which, in substance, I think it will play through. Risks then, just very briefly. First of all, the timing of all of this is unclear. We don't have the primary legislation yet. We don't know when it's going to be implemented, and we don't know what form it's going to be implemented. So whilst there's a lot of excitement in the industry, and I say that positively, I think the industry is gearing up for net gain and looking at ways to deliver it already. The precise point at which it will become a mandatory requirement is yet unclear. The Schedule 7A provisions anticipate real front-loading. In other words, you've got to get your head around the net gain position in advance of the application to make sure that you're going to be able to discharge the biodiversity gain condition. And I think that will be unfamiliar territory in circumstances where these sorts of things are often left as the bring of subsequent plans and so on. Local planning authority resource issues, to Tim's point, I think is going to be absolutely critical, because, as I've already shown, the determination provisions require the local planning authority to consider: has the assessment of the value of the site been done properly, assessment of the net gain been done properly, and overall the conclusion be sustained. And then, of course, practical delivery and enforcement, as ever, are going to raise issues. So with that tour of the legal provisions, I'll hand over to Dominic to talk about net gain in practice.
Thank you, Richard. So yes, tour of the architecture of the legislation. What I'm going to do is, what I'm going to talk about is what we might expect in practice in terms of practical delivery of biodiversity net gain. And for that, we can take cues from what's already happening, because in a lot of local authorities, they're trying to get out ahead of the curve and are adopting policies that effectively require delivery of 10% net gain prior to it being mandated, or they're adopting policy statements, supplementary policy statements that effectively retrospectively apply 10% as the figure for existing policies that determine have an aspiration towards net gain. So for net gain to be delivered, you've clearly got to measure it somehow, and this is effectively one of the problems with the delivery of net gain, and one of the challenges. We're talking about quantifying the unquantifiable. So in order to understand whether biodiversity net gain is delivered by land use changes, biodiversity needs to be measured and quantified. And of course, biodiversity is one of those things that actually least lends itself to simple measures of quantification. We're talking about the interaction of possibly billions of combinations, millions of combinations of biotic and abiotic factors, right through from geology, soil, water, interacting with organisms, and organisms interacting with each other. So highly complex system that you're looking to distill down into simple numerical calculations. And because of that problem, ecological impact assessment has always traditionally been the preserve of kind of educated guesswork, taking the word of experts such as myself that actually this mitigation scheme is good, that mitigation scheme is bad, this is a negative impact, that's a positive impact, etc. And to a large degree, that is based on educated guesswork and no small amounts of gut feeling. And in the context of planning decisions, the problem that's always presented, and the reason why government since the noughties really has been moving to try and come up with a more standardised system, is that that does not lend itself to repeatability, consistency and transparency. You might ask one ecological consultant whether this is going to be a positive impact from development, and you might get another answer from a different one and another answer from a third one. So that is what the objective of introducing a standardized system is. And this is where the metrics have come from. And the metrics are going to play this huge role in the delivery of the biodiversity net gain, and whether it's a success or not. Metrics are not a new thing. They were first mooted for introduction in the noughties, as I say. And then they were piloted as part of the biodiversity offsetting pilots around 2012. Various local authorities piloted the system. DEFRA introduced a metric-based system, and effectively what you've got today is still that same system. It's just gone through a number of iterations. Biodiversity offsetting had a mixed success, and it kind of went underground for a few years. But then with the 25-year environment plan coming out and setting measurable targets, it kind of went back up the agenda again. And then with the environment bill coming out, there was talk about standardizing and measurable delivery of biodiversity net gain. And so the metric got resurrected, dusted down, and revised, and a beta test came out in July 2019. That was used, and that's on the back of that, there was a growing use of metrics in planning decisions, whether overtly or less overtly. Consultants started to use metrics. Local authorities started to ask for metric calculations more and more, and these policies started to emerge for requiring 10% net gain using those metrics. The latest version, and the version which is intended to be used to secure the delivery of net gain once the Environment Bill passes into law, is Metric 3, published in July 2021. And just in case anyone is not familiar with how it works, I'm going to quickly run through. Forgive me if everybody knows all this already. But it's effectively a deceptively simple system. I've seen no number of planning officers and other people get slightly bamboozled by the metric because it looks extremely complicated. It's a multiple sheet spreadsheet with lots and lots of columns and drop-down menus and what have you. But the arithmetic behind it is unbelievably simple. Too simple, one might argue, in the context of what it's dealing with. So just as an example here, it's an area-based calculation which you then apply multipliers to. So here you've got an area outlined showing a patch of grassland on a proposed development site in the middle of those woodland areas there. Illustration of it to the top left. It's not particularly exciting grassland. So you can put it in as a classification of modified grassland, something between agriculturally improved and very botanically diverse. That has a default distinctiveness score, which is effectively the same as its kind of value. It's not a rare habitat, it's very common, it's not particularly unusual, so it gets a default low distinctiveness score. We'll come back to defaults in a minute, because that's where one of the problems with metric designs. You have the option to adjust its condition score, because you will get examples of low value habitats that are in very good condition, examples that are not in very good condition. And once you've putting aside a couple of other multipliers, such as whereabouts it is in the country, whether that relates to the nature recovery networks and what have you, that's effectively the arithmetic. You multiply the area by the distinctiveness score, by the condition score. You can see here 5 hectares multiplied by 2 for a low distinctiveness, multiplied by 1 for poor condition gives you 10 habitat units. If you wanted to then go on to the rest of the development site and start measuring the other habitats there, we've input there woodland, other woodland broadleaved. It's medium distinctiveness, again, it's a default. We've allocated it a moderate condition. You've got 16 habitat units there, and that gives you a total for a 7 hectare site of 26 habitat units. So that's effectively how the metric works in terms of assessing the baseline. Now you come along with your development proposal, and you want to assess what happens post-development. Okay, so you look at the post-development situation, you look at your master plan, and then you start to input these parameters. So developed land doesn't score any points. 2.5 hectares of that will go down to sealed surface development, buildings, roads, and what have you, as you can see in the image at the top left. Vegetated garden does get a score. So gardens that will come along with the development, they do get a score. It's low distinctiveness. There's a default condition of poor. And we've allocated that little area of open space within that development there as allotment. The local residents wanted allotments, the developer is giving them allotments. They give a fairly modest score. As you can see, the total units you get from that is 6.76. Where does that leave you? Well, as you can see, You started off with a baseline of 26 units. You ended up with a post-intervention figure of 22.76 units. That's a loss of 3.25 units. And that, because the site's quite small and compact, that's actually quite a significant loss, minus 12%. That gives the developer a problem. This is where biodiversity net gain comes in. The first choice to make is, do we try and deliver net gain on site, or do we try and deliver it off site? On-site net gain delivery quite often entails sacrificing developable area. And that might be unpopular, not just for the developer, but it might also be unpopular from the local planning authority's point of view. If they've gone to the trouble of allocating a site in order to achieve a set housing delivery, they want to make maximum use of that developable land. They don't necessarily want half of it given over to some public open space. And obviously that then displaces housing delivery to another site that might be even more biodiversity valuable. So on-site does have its own set of problems. We'll come on to some others in a second. The other alternative, you seek to compensate off-site, you max out your development, like in the right-hand image here, and you look to deliver your net gain somewhere else off-site. Either you define a site and you specify what's going to be delivered there, or you buy into a habitat banking system using conservation credits as the bill allows for. So if you go down the on-site delivery of biodiversity net gain route, these are the kind of things you tend to be talking about. Sud systems, green roofs, bits of tree planting around the edge, wildflower meadows. I've deliberately used that image because wildflower meadows so often end up being non-native species, and they're kind of fairly tokenistic. Those are the kind of things that often get delivered on site. And there is a general consensus amongst a lot of conservationists and a lot of ecological practitioners that on-site delivery tends to always be pretty limited in terms of what it can achieve. Obviously, there is a government impetus towards integrating biodiversity within developments, but that always tends to cater for only a very limited number of habitats and species. And those on-site elements always have to fight for their place alongside open space considerations, alongside the pressure from future residents to keep the place nice and tidy. So on-site delivery comes with its own set of problems, but is very often the preferred option for developers for obvious reasons, because they can wash their own face in terms of the development, and they don't have to be, their planning permission isn't contingent on delivery of something else that might require separate legal agreements and what have you. I've included bat boxes there because so often I'm asked by a developer, well, if we put up loads of bat boxes, does that get me my biodiversity net gain? No, it doesn't, because the metric does not count things like bat boxes or bird boxes or bee hotels or anything like that. Off-site approaches. So if you do end up in a situation where you're looking to deliver off-site, the prospects for what you can achieve tend to be much better from a biodiversity perspective. You can start looking at, for example, restoration of former hay meadows by the reintroduction of traditional grazing regimes, arable reversion of arable areas to heathland or Essex grassland or other types of habitats, reintroduction of traditional woodland management practices to ancient woodlands that have become neglected, restoration of ponds, and all of those kind of things. And it doesn't take much to think that you're always going to achieve probably a better result if you're dealing with an off-site approach. And obviously, the way the habitat banking system is intended to work is that if lots and lots of small developers put into pots of money, enough capital is generated to potentially deliver something much bigger and much better. So much more in accordance with the laws and principles of bigger, better, and more joined up. So from a conservation perspective, there's always this tension. From a conservation perspective, off-site tends to deliver better outcomes. From a developer's perspective, off-site generates all sorts of risks and additional costs, which they tend to be reluctant to. And obviously, so there's an impetus to try and deliver on-site. So in terms of delivery mechanisms, the way things are at the moment, the options tend to be planning conditions. There might be a condition for a landscape and ecological design strategy. There might be conditions for a landscape and ecological management plan delivered on site. Section 106 agreements might be put in place in relation to blue land, other land under the developer's control, or for entirely separate agreements might be put in place for entirely third-party land. I've been involved in the setting up of some of those, and it's a long, slow process. SIL is sometimes still used, or at least mooted for use in delivery of these kind of things, but obviously there are tensions with general local planning authority objectives for infrastructure levy funds for use for open space and what have you, so that tends to not come up that often. And there are, in various local authorities up and down the country, there are habitat banking initiatives underway where organisations have set themselves up to receive funding from developers to deliver offset habitat creation schemes to compensate for losses on development sites. After the Environment Bill becomes law, the new kid on the block will become conservation covenants. How different they will be from the existing Section 106 and unilateral undertakings is slightly, as Richard said, if the devil's going to be in detail. What will then happen to planning conditions and independent agreements and Section 106s and habitat banking initiatives? Will they just be subsumed within the conservation covenant system? Habitat banking initiatives are obviously kind of rolled into conservation credits and what have you, but there's a certain uncertainty about how the structures will work post the Environment Bill becoming law. So in terms of the issues looking forward, there are a whole suite of issues that the passing into law of the Environment Bill is likely to generate. The first thing is that, from my perspective, working in this field, everybody's waiting. Everybody's kind of holding back and going, what's going to happen? When's the Environment Bill going to become law? And then suddenly there's going to be a rush for land in order to deliver biodiversity net gain. Our local authorities sitting there most local authorities sitting there on a land bank saying, well, we've got this land ready to be used for that purpose. Chances are most of them aren't. Some of them are thinking about it, some of them aren't thinking about it at all. There's likely to be a rush for land for those kind of purposes. Some land agents are already thinking along those lines and are advising their landowner clients that there are opportunities there. Will there be enough land relative to housing need? I once did a calculation a year or so ago for a local planning authority in the southeast, looked at the number of houses they were looking to develop, looked at their allocation sites just on the basis of aerials, came up with a rough metric as to what they were likely to be able to deliver in terms of what they were likely to generate in terms of off-site need, and then looked at the amount of agricultural land available in the rest of the county. And it's tight. It's tight. There's going to suddenly be this demand for off-site delivery land. And when supply becomes short, is that going to drive the price of conservation covenants up? Is that going to be a fixed price, or is there going to be a market forces element to that? Who is going to pay this? Richard's point has been made already. Resourcing. Who is going to pay to enforce the delivery of these of net gain? Who is going to pay to enforce the scrutiny of the calculations that are presented to local authorities by developers? And what's going to happen when these things go wrong and when delivery doesn't actually materialise? That's going to put a huge burden on local planning authorities. I think DEFRA estimated it at 9.5 million a year. I'd say and there are all sorts of various other issues. Land banking risk. There's a possibility that, encouraged by land agents, farmers might club together and say, okay, we're going to hang on to this land, and we're going to get the best price for it, because we can look at the local plan and we can see what they're trying to deliver in the future, and we know that this land's going to come under the bar. Issues for landowners, potentially the conservation covenants will bind them in for 30 years. So here is a list of questions that I've heard when I've been essentially acting as a broker trying to set these sorts of agreements up. What happens then? Can I put my land back into agricultural use? Am I going to carry on getting paid? Will I then be able to re-enter an agri-environment scheme? What happens to my environment, my rural payments between now and then? If I do want to return it to farming, are you going to pay me to do that? Because that's going to be a major undertaking if it's all turned to scrub and woodland and what have you. What happens if my land is designated? What if it's so successful, naturally coming and snap and trip at a side designation? All of those kind of issues are kind of bouncing around in the thoughts of landowners and land agents. So another, I'm doing for time, but another concern that I have and I've seen happen is that all of these pressures and all of these concerns generate the temptation to potentially misuse the metrics. And the metrics are ripe for misuse. They're effectively a system that allows you to pick selections from a drop-down menu. So going back to the example we looked at earlier on, this developer says, I don't want to deliver off-site compensation. That's going to cost me an absolute fortune. It's going to take ages wrangling with lawyers and some third-party landowner, or I'm going to have to buy into some habitat banking scheme. I don't like the look of that. Can we do something on site? And then potentially they could say, I'll tell you what, instead of delivering lots, why don't we deliver lowland dry acid grass? That sounds great. That sounds nice. It doesn't matter that the site is effectively laced with fertilizers. It's never going to be able to develop that sort of habitat. You can just pick it from the drop-down menu, and as you can see, you get a much more palatable figure. change the future condition of your woodland from moderate to good without really specifying how you're going to do it, and you find yourself into a net positive figure. And therefore you've delivered what you need to. So the only way this is going to get picked up is if local planning authorities are well resourced enough and have the appropriate expertise in terms of ecologists to say that's not practical, or you've underestimated the basin. And that's happening, unfortunately, up and down the country. The other major problem with metrics, of course, is that it doesn't account for species interest. If you have a site covered in a whole load of old farm buildings, those farm buildings, because they're sealed development areas, will effectively score 0 in terms of your baseline habitat points. But what if they support greater horseshoe bats? They don't get any greater loading for that. What if it's an urban brownfield site that supports black redstars? You're not going to get an extra loading for that. What if it's a fairly rubbishy hedge that happens to have dormice in it? No extra points for that. So species are left out of the equation. The practical implications of that, what am I doing for time? I'm an idiot. The practical implications of that. So everyone would probably agree that this is going to be a fairly low scoring habitat, intensive arable farmland, nothing very exciting about that. But what happens if you suddenly put a flock of pink-footed geese and then you say, just over that horizon there's an SPA, which those pink-footed geese are directly related to, and so that this is functioning in land. Does the arable land get a greater weighting for that basis, or it doesn't? There's a default. You cannot even override it. You can't even go into the metric and say, I want to apportion that higher value to this. The metric won't allow you to do it. Another classic example, Cranscombe Farm, very famous site in Kent, arable weed farm, effectively, a place where plants that have almost disappeared with some modern agriculture are still thriving. It's a site of special scientific interest. It's an important plant area, plant life reserve, statutorily protected species, plant species all over it. What did it get on the biodiversity metric? Next to 0, this is called. Oops. Sorry, Josh, can you go back one? Overzealous. So thoughts to take away. Mandatory net gain, 10%, looks good on paper, and it could be a game changer. I'm not knocking the principle. If we can deliver net gain in reality, that's going to be a fantastic result. But who's measuring and who's checking the measurements? And are they being well enough resourced to do the job properly? The statutory and policy framework has never been able to be relied upon to ensure that weight based on ecological resources is always proportionate to their actual importance. The protected species legislation is still years behind what's actually scarce and rare these days. The Environment Bill doesn't suddenly change that, nor does the use of metrics. And being cognizant of these problems, whether you're a developer, a landowner, or a decision maker, helps to ensure that development designs and planning decisions have the best chance of securing biodiversity net gain in reality, and not just on paper. Do not assume that metric statutory bodies or even experts always have the right answer. Don't be afraid to get that second or third opinion. Stay skeptical. Thank you very much.
Thank you, Dominic.
Mine is the last paper and looks as if it's dealing to some degree with nuts and bolts, but it actually comes back to a number of the themes you've had today. Because if you read through the latter parts of Part 6, which are the new nature conservation strategies and habitats, and Part 7, which are the conservation covenants, you'll find a lot of features in common with all of the ecological provisions. And what you'll find is some broad principles set out, but a huge amount of the detail is left to both regulations and to guidance to be issued by the Secretary of State, which will have statutory force and must be had regard to by various decision makers. And one of the worrying aspects of these provisions is the degree to which they overlap and are confusing, and in some cases just clumsily drafted. The conservation covenants are incredibly clumsily drafted. You have a potential in this instance of habitats for the provisions for amending the regulations to potentially water down the current species and habitats protections in favour of a more broad brush biodiversity approach. And as Dominic has just explained, the problem with that is it doesn't necessarily pick up all the important protected species, and it doesn't necessarily pick up the important sites. And speaking as an owner of an old Kent barn, I know exactly what you're talking about, Dominic. But seriously, there's a serious lack of coordinated thought gone into these provisions, and it's a bit of an old Woolworths pick and mix, with respect. There is, I got very depressed reading the revised provisions. I've read them in various forms as they've come through, and it doesn't get better, I'm afraid. And there's now going to be, of course, a dispute over non-regression and habitats, which I'll come to in a moment, which is in clause 115 of the current version of the bill. How long that survives, we'll see. There's also a series of DEFRA revised policy statements reissued at the beginning of September, of which the Nature Conservation papers, part 6 and 7, I've given you the web link to. Conservation covenants, I've set out a lot of nitty-gritty detail, but I'm not going to go through it in detail. But conservation covenants, good idea in principle, it seems to me, a form of legally binding agreement outside the planning section 106 regime, and typically a form of public law covenant which will run with the land as a local land charge, and which will bind for whatever period is applicable, and I'll come to that, the parties to it. The responsible body, which is always an use of responsibility is always interesting. Not quite the same as public body or public authority, which have different definitions throughout the Act. But it includes the Secretary of State, interestingly, and any other body designated by the Secretary of State. Conservation includes protection, restoration, or enhancement, and may include positive or negative obligations which have a conservation purpose. And then, oddly, they have to be intended by the parties to be for the public good. One would have thought that that went without saying, bearing in mind the purpose that was set out. So that's one of my little niggles, appears superfluous. You've then got a very odd provision, which is about qualifying estates. You can enter into a conservation covenant and be bound by one if you're a freehold owner, and the owner of a leasehold interest, which has been granted for a term more than 7 years. But it says, in the case of which some part of the period for which the term of years was granted remains unexpired. So what if it's just 6 months of the 7-year term? What if it's 3 months? It doesn't appear to have been properly thought through. If it's intended to create long-lasting benefits, one would have thought that the 7 years might usefully have been targeted at the unexpired term granted, but there you go. There is then another incredibly clumsy device. Having defined conservation covenant agreement in clause 120, the mechanism of the Act, of the bill, then gives it statutory effect under clause 121 as a conservation covenant. Well, why bother? Why not just say that the conservation covenant agreement, which fulfills the requirements of 120 within 120, is a conservation covenant? I mean, it's just clumsy drafting. And it can include not only the provisions which may be spelled out within 120, but ancillary provisions which include public access arrangements. It takes effect as a local land charge, obligations owed by and to the responsible body, wide range of enforcement mechanisms, and there is a default period. So if you don't specify the time for which the covenants last, if you're a freehold owner, you've committed inadvertently to an indefinite covenant. The remainder of the term of years is the length of the covenant in the case of leasehold. So if you have a lease of 7 years with 6 months unexpired, it can only be 6 months. Interestingly, can conservation covenants be used instead of planning obligations in planning applications? If I were a local authority, I would be thinking quite hard, given the specific target of the conservation covenants, that this might be a better mechanism, given it's got better enforcement mechanisms, damages, injunctions, specific performance, a whole range of remedies, not just the injunction that's available to enforce a planning obligation. But, of course, the SIL regulations and the legal requirements for taking them into account in order to determine the planning application in Reg 122, necessity, proportionality, etc., don't appear to apply to conservation covenant. So would appear on the face of it in the planning context to give much greater flexibility to local authorities. And then, as I say, wide range of remedies, a number of defences, such as was outside my control. Well, that's fair enough. And there's a provision for modification and discharge, not the Section 84 of the Law Property Act provision, but there's a separate provision set out in schedule to apply to the upper tribunal. And that includes the power of the upper tribunal, or indeed the court, to declare whether the conservation covenant is a conservation covenant and on whom it's binding. So potentially very useful, but really the drafting could be significantly improved and tightened. Habitats. Now, this is interesting. Clause 115 was introduced at the report stage by Lord Krebs, and it seeks to impose a principle of non-regression, an absolute principle of non-regression, rather than, he said, the Secretary of State marking his own homework, which is what you have in clauses 113 and 114. Clause 113, understandably, allows for clarification of the scope of Reg 9, which is the old provision which imposes on those bound by the habitats regs to comply with the directive duties, that is Habitats Directive and the new Wild Birds Directive, when they're exercising their functions. That, of course, could be seen as rather broad and vague, and this allows some further clarification by regulation. It's stated confidently, as I say at the bottom of this slide, that the power will enable alignment of the regulations with our new world-leading targets, particularly the 2030 species abundance target and our binding international obligations. Well, it will, but there's no duty to do that in the regulation amending power. So we'll see. The regulation states that it may impose requirements for biodiversity, etc., and other objectives leading to the conservation or enhancement of biodiversity. As we've already heard, the enhancement of biodiversity is a bit of a double-edged sword, because it may be a lower common denominator that we would like to apply, bearing in mind the tight controls over species and habitats protection. And here we have the first instance of the Secretary of State marking his own homework. Secretary of State can make regulations having regard to the particular importance of furthering conservation and enhancement, and allowing a non-reduction of the level of environmental protection provided by the habitats regulations. But in the case of both 113 and 114, which covers Part 6, the appropriate assessment, plans and projects section of the habitats regs, it's only the Secretary of State who has to be satisfied that the regulations don't reduce the level of environmental protection. So it's a modified, as I say, self-marking non-regression principle. And although it requires affirmative resolution procedure in Parliament, nonetheless, it's a matter of political control rather than guarantee. And one of the oddities, which I'm afraid to my suspicious mind gives you a clue as to what is going on, is that the September policy paper, and indeed the explanatory notes, if you get as far as paragraph 956, it's to improve the natural environment, make the processes clearer and more legally certain. Well, I don't understand what is legally uncertain about Part 6. Yes, the provisions are very rigorous. See Lord Carnwath's judgment in Champion. But the test, that is to say, that adverse effect on integrity has to be considered on the basis that there is no reasonable scientific doubt. And it's not an absolute standard, but it is a very rigorous standard, having regard to the best scientific evidence. Those principles have been reiterated time and time again by the European Court, endorsed and applied by the UK courts, particularly Lord Carnwath and Champion. There's nothing uncertain about that. It's clear. It's tough, but it's clear. And of course, it's generated issues. And I give an example of nutrient neutrality, which is a current problem, and the Wyatt case, which may or may not go to the Court of Appeal, which Tim is for the local authority and I'm for natural England. But the issue there was one of whether the local authority had properly applied the guidance, whether one part of the guidance was perhaps not properly applying the legal standard of certainty. But there was no question about which principles should be applied. And if you contrast the 2012 report on habitats, you'll see it didn't raise issues of legal certainty. There were issues of clarity here and there, but not legal certainty. I'm afraid what I read into this is that this reference to legal certainty is merely saying we don't really like the fact that it imposes such a high test. And it would be much better if that is what is meant, given that there is a clear principle that can be applied, is to be honest enough and transparent enough to set it out in the policy paper, then at least we know what we're dealing with. And clearly I'm not the only one who's cynical, because Lord Krebs introduced clause 115, which may not survive the report stage, or if it does, may not survive ping pong in the Commons. There, the Secretary of State's opinion was removed from the non-regression principle, and it's simply made as a principle of statute, which, if it survives, will be the only hard-edged example of non-regression within the Environment Bill. I somehow doubt that it will survive. Oops, I've gone backwards. And there you see Lord Krebs referring to ministers marking their own homework. The Minister, Lord Goldsmith, opposed the amendment. It was substantially voted down at the report stage. And Lord Goldsmith is on the simplicity issue. I have to say, I regard this constant reference to simplicity with a heavy pinch of salt, bearing in mind the complications and confusion which this bill will generate. It is not simplicity. As I said when addressing a group of judges some years ago, it is a truth universally acknowledged that when the government claims it is simplifying a system, the reforms it introduces usually has precisely the opposite effect. With all respect to those who I know and respect who work in government, simplicity does not appear to be a watchword. Lord Goldsmith said, I can commit this House to this House. No changes will be made without extensive consultation, strong parliamentary scrutiny. All that means is we may be able to reduce it, but we'll have to go through a process. It doesn't apply a hard-edged legal test. It doesn't provide a principle of non-regression that was in the original version of the Northern Ireland Protocol, which bit the dust some years ago. Note also, most of the duties are have regard duties, other than this clause 115, which is a weak duty. The Secretary of State has to be satisfied, and although he has to explain why, it allows concerns, it generates concerns about erosion, particularly since there is not a clear trade-off between biodiversity and biodiversity gain, and actually protection of that which is important, which are habitats and species of some rarity, which are perhaps more adversely affected by climate change than others. Regulations guide the making of regulations, and the interrelationship of existing and new strategies is simply unclear. So how far can you go, I ask, in simplifying ecological and general science in any event? So let's go to the strategies for this simple approach. Bear in mind, we've got 3 new sets of strategies under Part 6. We have local nature recovery strategies, species conservation strategies, and protected site strategies. All of them are to cover areas, specific areas in England. All are to be put forward by Natural England, where Natural England is going to get the resources from when they're already stretched, to be reviewed from time to time. Of course, the procedure will be dealt with by regulations. There will be there is some guidance as to content, but there is a general duty to have regard, here we go again, to any guidance made by the Secretary of State as to the information to be included within the strategy. species conservation strategies, a new mechanism to safeguard the future of particular species at greatest risk. I thought we already had one. I thought the habitats regulations was just that. Well, find better ways to comply with existing legal obligations. There you go. Fiddle again and see whether, in fact, it turns out to be better or whether we're weakening despite the good intentions set out in the purposes behind the bill. There you see what species conservation strategies can include. Interestingly, planning authorities and any prescribed authority must cooperate with Natural England in the implementation and preparation of strategies so far as are relevant to their functions. Does that mean they have to comply with the advice regarding approvals and measures? Because Natural England can give global opinions for that area on giving of approvals and consents and for mitigating and other offsetting measures. Does that mean, for example, a planning application must comply, the local authority must comply with the strategy? It's worse than that, because not only is there uncertainty here, there's a doubling of effort. If you actually just park your thoughts on this for one moment and just turn your minds to NERCA at section 40, clause 103 of the bill introduces a new general biodiversity duty. I'm not going to go on about that, but it's got a number of problems. However, clause 103.5 imposes a duty on local authorities to comply or to apply the various strategies under Part 6. So, nature recovery, species conservation, site protection. So not only have they got to cooperate in preparation and implementation, whatever that means, but they've also got a duty when they're discharging their planning functions and other functions under section 103, which will be under section 40, subsection 2A of NERCA. So there's doubling up. And yes, you guessed it, there is also going to be Secretary of State guidance to which they must have regard while they're discharging their duties. So we've got two layers, each overlapping without any clear indication as to the intentional relationship between the two of them. You see what I mean about clumsy drafting? Protected site strategies, much the same. You might have thought SSSIs, SACs, SPAs, etc., was quite enough for anybody to deal with, and Natural England has a job to do with regards to those and limited resources. However, here again, we have, you see what site strategies may include, and you can see that there's a huge overlap with a lot of matters which are already considered in the context of the habitats regs, including an assessment of the impact any planned project or other activity may have on the conservation and management of the protected site, measures that would be appropriate to take to avoid, mitigate and compensate, etc. Again, there's to be consultation with public bodies, but only the public is only consulted if Natural England considers it should be consulted. Contrast the mandatory consultation with landowners for SSSI notification under the Wildlife and Countryside Act. That is odd. Those who are lucky enough to be consulted by Natural England then have a duty to cooperate with Natural England in the preparation of the strategy. So any public body that's consulted must then have has a duty at the choice of Natural England. And of course, the Secretary of State may give guidance to which regard must be had. There's a pattern emerging, isn't there? And then we have under 1110, then you've got to have regard, the person must have regard to a protected site strategy so far as relevant to any duty under the habitats regs, the licensing provisions of the Wildlife and Countryside Act and the Marine and Coastal Access Act. But that is also subject to the overlapping duty in relation to the general biodiversity duty, which then specifically refers to this strategy as well. So back to section 100, clause 103.5 and the proposed new section 40, subsection 2, capital A of NERCA. The new strategies are potentially more far-reaching than policy or notes suggest. They do appear to confer a much wider power on Natural England in respect of species, protected sites, nature recovery, intended to be more influential on local authority decision and plan making than at present. As if habitats wasn't rigorous enough and SSSIs didn't impose sufficient controls. The various duties to cooperate, which I may point out has not been a particularly successful concept in plan making and the planning sphere, gives rise to a number of uncertainties, dispute, and of course, as I say, the clause 103 NERCA duty. It places quite clearly considerable additional burdens on Natural England, local authorities and other public bodies, it's difficult to see how, without much greater resourcing, already stretched public bodies are going to be able to deal with this sensibly and in a manner which creates better protection than we have at the moment. It's the risk, indeed the likely confusion, which the new will cause, particularly with the drafting and the overlapping provisions that I've indicated. So the relationship between the new strategies and the new the new strategies and the existing species and habitats protection is unclear. It clearly overlaps. To some degree, what's going to happen will depend on how biodiversity net gain develops, how the general biodiversity duty is developed, and what happens in terms of reform of the habitats regulations. But there is at present no clear strand you can hold other than fine promises that are made. And as I say, the only clear legal reference to non-regression is in the controversial clause 115. I'm not going to, you'll be pleased to hear, talk to you about trees, other than to say that there are new controls being introduced, particularly for consultation highways authorities who are trying to lock trees in the street. Although you are allowed to lock trees in streets to make reasonable adjustments or avoid discrimination under the Equality Act, which I found an interesting exception, but I suppose I can see why. However, what is important is the ancient woodland, ancient and veteran trees are going to have considerably more protection, and direct loss is to be prevented except in wholly exceptional cases or for wholly exceptional reasons. So that's a point that people will have to grapple with. Why we have certainty with regard to ancient woodland and we can't have better certainty with regard to habitats, I don't know. Well, it's because it's much more controversial, I suppose. There we go. I'm afraid I've served up some detail, but also a lot of concern. Similar reasons as other speakers have expressed concern with regard to the bill today. Thank you.
Gets the sense that whole generations of native fauna would have come and gone before this system is brought into effect. The amount of strategy making, policy writing. I want to know who's going to do it. Anyway, thank you very much to our speakers. Now we've got a little time available for questions and discussion. Are there any questions from the floor, first of all, in the room itself? Yes. We'll just provide it.
Not having talked, my voice is given out. No mention has been made of green corridors and indeed local nature reserves, which are enormously important. I mean, if you talk to an ecologist, you know, it is the communication between the different bigger nature reserves which keep the interchange of species going. And my other point is that from bitter experience, local authorities just haven't got any money for qualified officers of any sort. Nature conservation is way down the bottom. You've got some 23-year-old straight out of college who is totally overawed by some, aggressive developer. And yes, of course, you're allowed to lop all those trees down. And yes, of course, in due course, this will be, turned into housing land. But I did wonder whether we could talk a bit about green corridors.
Well, I think the question of where does all this new interlock with existing well-established arrangements to preserve arts and conservation.
Yes, well, interestingly, the metric 2 did have a multiplier that sought to kind of build in connectivity, but that was a victim of the transition to metric 3. In defense of those who made that decision, I suspect it's probably because metric 3 retains this multiplier to do with whether the site is within a nature recovery network or some other kind of spatial strategy to do with biodiversity recovery or biodiversity conservation. And they would probably argue that it is assumed that if the connectivity has been part of that design process, and that then carries through into metric 3. But it was interesting to see that the connectivity multiplier, which aimed to basically say if the site is well connected to others in the locality, so your point about connectivity and how important that is, that was incorporated in metric 2, but it's since gone. Local nature reserves, your other point. I mean, the biodiversity metric aims to kind of assess the baseline value regardless of designation or otherwise. Obviously, it's not intended for use for statutory sites, but if a site is a good point. I mean, if a site has a local wildlife site designation, for example, should it get a greater weighting? Because at the minute the metric does not give it a greater weighting.
The other thing that occurs to me that green corridors and the like are more likely to be protected at the local level, and if they don't appear, for example, in protected site strategies and the like you may find that local designations are having to give way to whatever it is that Natural England brings out in terms of, of its various strategies. And one of my concerns, as I've already indicated, is how the new fits together with the old. And there's a risk the new will override the old, particularly in local planning choice concerns, because they're having to give effect not only to the duty to cooperate with Natural England in implementation, but the duty under the, which will come in under NERCA, section 40, subsection 2A, and local authorities will be squeezed when they try to put forward their own conservation strategies, because they will have to be consistent, more likely with the Natural England ones. Where local, I mean, I entirely share your concerns, because I work for Natural England from time to time and for local authorities. And I know both are stretched and are doing their best to keep up with work, but it is a losing battle on many occasions. And I think this is just going to add more to their concerns, not quite apart from anything else, because people will and organisations will be struggling to try and understand what they have to do.
Thank you, David. Recover. Two quick questions. One, Dominic, was fascinating about the metrics. I wanted to understand that I understood one aspect. The biodiversity net gain, it seems that you were saying you get much better gain from off-site projects. Is an implication of that is that planning will become more dense and you have less open space? I mean, that it feels to me like there's a trade-off between open space and livability and green space in development, and that an unintended or an intended consequence of biodiversity net gain done well might be actually less livable spaces in development. So that I kind of just wanted clarification on that. And David, your point about knowing what the law is quite difficult, but there's now this pattern which you were highlighting in the or the nature conservation sections of local authorities having other authorities work with them, and ways in which other authorities have to work with them. And you also see that in the air quality, new air quality powers. And I wonder whether it's not just about resourcing for local authorities, but they're going to have to find these whole new organisational ways of working with lots of other public authorities. And I wonder whether is there scope that will end up in a kind of a nice networked pattern of public authorities, or is this just stresses and strains and passing the buck and risk?
Eloise, my small hint in parentheses was that the duty to cooperate in planning, in plan making, under the Localism Act has proved a bit of a, well, curate's egg, is that being polite?
Have to be host.
Yes. Yeah. Yeah. Well, and it's natural England can demand the cooperation of the local authorities, not the other way around. And local authorities owe a duty to them to cooperate both with regard to formulation and implementation. So, yes, I know I'm not sure it's been properly thought out, because where is the local authority going to find on a regular basis the sort of expertise that it will need? Local authorities can't afford in-house ecologists these days, or most of them can't. And certainly from local plan work, I know how difficult it can be to get the expertise in within a reasonable time frame in order to allow work to be done so that other duties can be complied with. So it's a real issue. I mean, I agree that, you know, it would be good if there's some new form of cooperative working could be set up, but yeah, maybe it's another job for the OEP.
Dominic, do you want to deal with the
Yes.
issue of offside, onside?
Yes, thank you, Eloise. I think the answer to the question is there's a tension there between the direction of travel for some time now has been improving contact with nature, integrating biodiversity with developments, having biodiversity permeating through developments in research schemes and what have you. The problem then arises as to a qualitative assessment of what kind of biodiversity you're talking about, because the types of biodiversity you tend to deliver on site tend to be the kinds of things that do well, synanthropic species effectively is the technical term, species that do well living cheek by jowl with people. And they tend not to be the species that are in the highest amount of trouble. So if you want those high targets and that high level of biodiversity delivery, you kind of need to be looking at off-site delivery. I think the way the structures are set up at the moment is I think the developers will be very eager to deliver on site. So I don't necessarily see that it will automatically result in denser developments, but there may be pressure in some instances, particularly once the systems are up and running and off-site delivery becomes easier, the temptation to go for denser developments, and potentially that might be a temptation that's pushed out by a local planning authority as well, seeking to deliver housing targets. That might end up in the long term, but I think we're a good way away from that yet, because I think you've still got this residual framework that wants access to nature and enjoyment of nature to be right on site, right on the doorstep, but it's what kind of nature are we talking about?
We've had a number of questions from people attending virtually about the question whether these requirements will apply to small scale developments. Richard, I wonder if you could just address that, householder schemes and that kind of thing.
Yeah, well, I think again, it's net gain. Devil is going to be the detail of the regulations. The government's indicated previously that there'll be exclusions for certain types of development, and there's power to deliver exclusions. But beyond development and permitted development rights, there isn't an exclusion on the face that would have to follow. So yes, we will see it, but there are going to be threshold questions then, as there always are. I take the example of SIL, not because it's anything to do with it, but because it's an example of the government saying, well, let's find a way in which we can extract a generalised benefit from developers. And then by regulation, we'll work out a way of setting thresholds and criteria for delivering it. And others will judge whether that's worked or not worked. And local authorities have lots of $6 billion worth of SIL money, so that may be a sign that it has worked. But equally, it's led to a lot of confusion on threshold questions in its implementation. When does it apply and when doesn't it apply? So yes, we will see exceptions, but then those will be the bits that are litigated and so on. So the complexity is to come.
I mean, it seems to me the logic of the bill is to secure a national, an audited shift. That is to say that in 5 years, 10 years time, whatever it may be, the development sector will have generated nationwide a 10% improvement measured against the metric in national biodiversity.
Only on the sites that are developed.
Yes,
I think that's why
what I mean.
it's
By
kind of,
development, development.
yeah. And I think the important thing is, as far as I'm concerned about that, is that, you know, when we're reading at the weekend about the critical state of biodiversity in the UK and the real fundamental problems, you don't fix that by saying that every bit of new development must deliver 10% more than it's lost. I mean, you're looking at a reduction of biodiversity of, you know, figures 80% over the past 60 years or something, with the press this weekend. We don't fix that by saying if you build a house on a field, then you've got to deliver 10% more than you lost from that. You've got to fundamentally reverse.
Yes.
It's only ever going to be a top slice. And I think maybe on the local networks, green corridors and so on. Well, yes, but the development industry is going to fix it. Somebody else is.
That's one of the problems, is that development, this is about development playing its part in a wider recovery strategy, but where are the other elements? Where is the 10% net gain for agricultural land use? Where is the 10% net gain for transport infrastructure necessarily, or marine uses? So without a kind of an across the piece drive towards 10% delivery, then even if this is successful, what we're going to get is a small part of the solution, but by no means the whole.
I remember the 30 years ago now, that the focus was on a particular species, namely human beings, and those who couldn't afford to buy housing or to rent housing at market rates. And the solution to this would seem to be introducing the notion of affordable housing as a material planning consideration.
Yes.
Right. Yeah, and I wonder whether that's been entirely successful in addressing housing need over the past. Are we embarking on another exercise of that kind? Mustn't be too soon. Anyway,
I mean, the various conservation strategies that I've outlined, they're not restricted to planning and development, and they may clearly extend wider. How wide is another matter. Just of necessity, they're fairly general in their terms.
There also still seems to be this fixation on protected sites, regardless of what rules are saying about what needs to happen in the wider countryside.
What this system clearly assumes is a significant level of cooperation from that.
And yet they're not consulted on, whereas they are for SSSI notifications.
That to me is the delivery question. Is that level of buy-in? And what sort of price will they look for?
That's the incentive will be money.
Yeah. And that's the question. And I think that's probably as good a place as any to end, because that's, you know, it's not the only big question, it's one of the big questions of this legislation needs to answer. But that brings us, I think, to the end of this conference. I'd like to ask those of you attending here and indeed those online to join me in expressing appreciation for the speakers we've had in this final session. Thank you very much indeed to all.
And as chairman of our environmental steering group, can I just repeat my thanks to everyone who's spoken today, and the excellent presentations and the thought-provoking, if somewhat depressing, views that have been expressed during the course of today. Thank you to everyone.